Good evening, everyone. I'm going to call this meeting to order at 6 p.m. Would you please stand for the...
They're still playing.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Staff, can you please call the roll?
Doug Chadwick,
Here.
Eamon Collins,
Here.
Liz Darrow,
Here.
Joe Ellenboss, Lindsay Graham Ellenboss,
Here.
Colton Kaltenfeld,
Here.
Brad Kelly,
Present.
Maya Morales,
Present.
John Muchler,
Here.
Hannah Ordos,
Here.
Joel Pitts Jordan,
Here.
Andrew Redding,
Here.
Jessica Ramstra,
Here.
Rod Stump,
Here.
Jennifer Wright.
Here. Thank you. We're going to move on to approval of the agenda. First, we have a procedural motion related to proposed amendment 13. Commissioner Ordos.
Yes, Madam Chair. I would move to rescind the Commission's previous action regarding proposed Amendment 13. The vote that occurred addressed only a partial component of the amendment according to our adopted rules and what was included in our agenda, and the remainder was never debated or voted on as intended during the body's discussion. This procedural oversight invalidates the assumption that the entire amendment passed. I propose to correct the record and readdress the full language properly following consideration by paragraph, or if it's the will of the body, Amendment 19 can serve as a substitution if this passes. Whether this passes or not strikes at the heart of our parliamentary integrity under Robert's Rules of Order. So I ask my fellow commissioners to support the motion to rescind so we can move forward with clarity.
Second.
Commissioner Redding.
Yes, I want to object to this. Yes, we don't have, oh, it's the owl that does it today, okay? I want to object to this because look, we get first of all, on any kind of motion to adopt, we first have an introduction and then we have, a vote at a subsequent meeting. Now, I'm not suggesting this requires an introduction per se, but I do think that there needs to be proper notice on something to remove what has already been adopted. This came in only a couple of hours before the meeting. And so I would like to submit that this is something can be perfectly dealt with at the next meeting, which would have proper notice. It's only when we're adopting things that this is the last meeting for doing so. And at the next meeting, we are free to rescind anything we want to, I guess, under this rule that I didn't know about previously to a couple of hours ago, but there doesn't need to be proper notice on that is my position.
Is there? Oh, go ahead, Commissioner.
I guess I was just wondering, so if it's not voted on tonight, but it gets rescinded at a later time, like if 19 passed tonight, then we could potentially rescind it in future. Is this what we're discussing? It doesn't have to be done tonight because it's not something to go forward. It would be something to remove, which we can still do. Is that correct understanding?
Yeah.
Okay. And I think like there is like legitimate confusion around that meeting that people have had, and so I guess I would ask if we don't do that when we consider 19, but just consider it thoughtfully as a potential substitute.
Yeah, thank you. I'm still, I guess, a little confused on exactly the chain of events that happened at that meeting. It sounds like there's definitely some conflicting opinions on what warranted what. I know Helen have weighed in. I guess I'm just curious here. So, assuming that that amendment doesn't get rescinded, but we do pass 19 today, we kind of have these two things up in the air. What would happen in a situation like that? Do both just go to the voters, or how?
They're right now set as two separate amendments, so if we pass 19, both 19 and 13 would be presented to the voters on the ballot.
Okay. And if, what happens if one passes, not the other, or both pass?
If both pass, they'd be reconciled since Amendment 19 contains the change that is made by Amendment 13. That would control, essentially, that would be what would affect the charter.
Thank you.
I just wanted to say that I think it makes sense that it could be put on a later agenda just to give this agenda more spaciousness for the new things that we actually need to do. That makes sense to me. Because my understanding is that this was our last meeting to bring and vote on the new stuff that we put on, right? Am I wrong?
This is the last meeting to vote, yeah.
I'm speaking for myself, obviously, but that meeting, when we approved Amendment 13, was to approve only the tying the election, as it says here, tie signature requirements for charter review amendments from the public to county executive electors rather than gubernatorial. And when Councilmember Redding was asked about numbers, the impression I have, it's a very complicated conversation, but there was to be no number, not the old number, not a new number. But then we were going to come back later and decide as a body what was our comfort zone in terms of percentages. That didn't happen, and somehow, I'm not blaming anybody, but if you go back and listen to it, it is not at all clear what the intent of that thing. I mean, actually, I think the intent of the commission was clear. It was that we'd like to tie everything to gubernatorial elections, but we haven't decided on a number yet. That was my impression. That's what I voted upon. And it doesn't appear that's where we're at today, because we now have a full amendment going to the public with the old number, which was 15%.
Yeah, I would just concur with what Commissioner Munchler said. I think like if you look at the votes, a lot of, was a pretty strong vote in favor because of, I think, the goodwill to come back to look at the numbers. So I think that there wouldn't have been the votes that there were if the understanding was that it was just like tied to that forevermore. So I just, as a matter of integrity, I think it's important to say that. And I don't know about rescinding tonight because I do think it's important to spend the time on the agenda that we have. But I just think if other people, I think there's just a lot of people who saw it that way, so it makes sense to me to reconsider that. Or when we do 19, to just try to do that very collaboratively so that we can hopefully rescind or have it combined or something in the future.
Sorry, twice, but I feel like we need to exercise great caution with this kind of thing. Once we have voted something, I think going backward and reading into our intent and interpreting that and deciding that people voted that way because they felt this way, I think that really kind of messes up our process. And I think what we have is a disagreement about, what was the nature of that vote and what were the understandings of the people who took it. At the same time, I hesitate to come to a kind of conclusion that throws things up in the air because I feel like that could be applied to any single thing that we voted for. And I think it's better to just attend to our process and know that we firmly voted to tie it to executive, leave it at that. And I think it's very risky to sort of get into this gray, wavy gravy space. So I just wanted to say that.
Commissioner Stuff.
I agree with Jennifer. Integrity is more important than anything else. If we don't have integrity in this group, we have nothing. So I think we should revisit it.
Is that a hand, Commissioner Ellenboss?
It is, but I'm patient always.
Okay, Commissioner Goldberg?
Yeah, no, that totally makes sense. And to the extent of like we're setting precedent for process, I do want to be mindful that we are also like at the end of the process. So it's not like we're setting any precedent that we can later follow up on. I guess my preference here would be if you want to move this rescission until later in the meeting, I'd be curious to see how the conversation goes in regards to amendment. Oh, sorry, I'm so bad with numbers. 19, thank you. See if we can work collaboratively on that. I know, there's a big gap between 15 and 25. Maybe we can meet somewhere in the middle there. And then if we all get to an area that we feel comfortable with, we could just then vote to rescind that old vote, start clean, and have a nice package. To me, that seems like the better option, so we kind of know what we would be voting on when we're rescinding. But I do definitely respect wanting to honor the intention of my commissioners when they vote, because I would want to be extended the same respect and consideration.
Commissioner Ray?
So yeah, I think, Helen, I wanted to ask, is it possible to, is there some kind of, or maybe Commissioner Elmas, is there some kind of motion to like combine? So we didn't have to set a precedent of like if 19 passes, would there be like, could we do whatever the legal term you said was, where they're like put into alignment? Can we do that before we send to the voters? So we don't have to set a precedent of rescinding things?
I think I would probably classify that action as a motion to amend something previously adopted, which is kind of a partner motion to the motion to rescind. It can be done at any time without notice, requires a 2/3 vote without notice. I think if you're talking about what you're sending to the voters, I think it probably would require 10 out of 15 anyway because of the charter language. I believe that is the proper mechanism for doing something like that, amending the previously adopted motions to combine them into one charter amendment.
Okay, so we could, if 19 passed, we could, not my wheelhouse, we could move to, say the words that it would be, amend those
something
two previously adopted amendments, and then proposed amendments, and then we would combine them.
I mean, presumably, if 19 passes, it's going to contain the entirety of the changes that are included in 13. So I don't know that substantively it makes much of a difference if you call it rescinding or amending something previously adopted. You still end up in the same place, I guess.
It's true, but the vibe and the feeling will be different, and that's very important.
Commissioner Redding?
Yeah, again, I see no problem with having this discussion, but at a properly noticed meeting. I have had no opportunity to prepare any kind of response. That's the whole thing with notice. I've gotten no notice, no opportunity to prepare, nor have others here who weren't aware this was coming up. So I do want to ask that for the basic respect for process here, to have this placed on the agenda for the next meeting with proper notice and proper preparation.
I was just gonna say, this matters important to me. It was Todd Donovan and John Musher that brought an amendment proposal 10 years ago to lower from 20 to 50% of the gubernatorial. It received bipartisan support from the commission. It was 10-5, and it wasn't one side or there was a fair split. When it went to the voters, there wasn't even an opposition statement in there, and it passed by 61%. I think because it was bipartisan that didn't pass. But that was a big leap from 20 to 15%. Now we're going from 15% of the gubernatorial to 15% of the local executive race. It's a huge jump. And I think it diminishes all of our work here on the commission to have such a low bar for the public to be able to initiate these things. I feel like it has been notified that when we had the original motion, and I listened to Commissioner Reddy, it was left open the amount. It wasn't, let's keep it the same amount, let's say 15. It was clearly intended to come back later and debate the amount.
Commissioner Redding?
What we're doing here now is getting into discussion of the merits, exactly what I was hoping we would wait till next time for. But since this is happening, I've got to emphasize here that under the existing one, okay, the 15%, the amount of signatures you would need is 15,000, and the maximum we've ever gotten is 13,000. So it's not as if it's an unreasonable thing. 15,000 when you add in the amounts that the auditor said you have to have a 25% surplus. The 13,000 that was the maximum ever turned in was the amount turned in, not the valid signatures, the amount turned into the auditor. This would require 15,000, a very difficult hurdle, even at that rate. You put it back where you're proposing, it would be 25,000 with that 25%, and absolutely impossible. And I guess that's what you want, because that means that way there will be, as there never has been before, an amendment from the public. And I think that's a very serious matter. That's saying you don't trust the public, even though it says very clearly in the charter that that is one of the 3 legitimate ways to get something on there. Why are we so afraid of the public? That even requiring more signatures than have ever been obtained before, that's not enough. I'm seeing fear of the public here. And if I'm very honest about it, one of the things you're not wanting to have the public ever do is have an opportunity to put RCV on the ballot. That's what I think is motivating this. And this would in effect block it. And it would mean that since you can't do that through the county council, that's blocked there, you need unanimity there, which means a single objection keeps it from going on the ballot. That means there's only one way to do this, by Charter Review Commission. And even then, every 10 years, it's minority veto. So you can't do it that way either. So it's kind of a way to make sure it can never come before the voters. And that's not democratic, I'm sorry.
I just want to, we've talked many times about how we want to communicate with each other and being respectful of this process. And what's happening right now is completely contrary to those discussions that we've had. And we don't need to engage like this. We weren't talking about why, we were talking about the technicality of what happened and how it should look and what people thought. And I do think that's an important precedence that we could set, not a negative precedence, that we are willing to look back and do the right thing.
No, I mean,
Commissioner
Commissioner
Ortiz.
that I want all of mine heard and voted on.
You want what?
I want all of mine heard and voted on then.
You didn't even vote on other people's every time. How can you say that?
Okay, no, we're getting into the weeds here. Commissioner Ordos, did you have a thing to say?
Well, I want to respectfully disagree with Commissioner Redding, and this is at least the second time that there's an accusation that's been made about my intent, why I brought something forward, which I think is wholly unfair, because I do not recall the time when I have done that to any other commissioner at this table. I have not set a precedent in any way in my time on the charter to be one that disrespects the time of this commission. I've always been very respectful in bringing things forward in the time that I take in front of the commission. So I would like that just to be noted. Couple of errors that I would just like to go back on. 25% equals 20,511 votes. 20% equals 16,409. What we're talking about is the 15% of the executive, which was 12,306, which is a 41% reduction in what we currently had it being 15% of the gubernatorial. My reason though for bringing this forward is after review of the agenda, the minutes, discussion with the parliamentarian, legal counsel, and going back on all those things is that we had procedural errors that caused confusion, whereas there was individuals that voted in favor that would have voted differently had they understood that the intention was not to go back and look at the numbers. There was specific discussion with Commissioner Redding talking about 20% and 15%. There was a lot of dialogue that was happening, and with all due respect to Commissioner Ellenboss, he mentioned the term bifurcation, which is not something you can do under Robert's rules, and gave you, Madam Chair, an option for us to move forward since we weren't going to do this in committee. What happened at that point is you made a comment that that's exactly what we have a motion to do right now. Then we closed debate. We went directly into a vote. And there's only 2 courses of action we could have taken as a body. And that would be to either someone say, we need to call a procedure or divide the question, which would have effectively did what happened, was that we would have taken 2 items that were clearly on our agenda as part of that proposed amendment, which was a strikeout with a percentage intended to discuss, and then whether or not what race it was going to be attributed to. But we did not divide the question, because that would have meant that you as the chair would have had determined that we all would have had to voted with clarity that those 2 components were not interdependent. We've listened to Commissioner Wright and Commissioner Muchler that had they understood that those were going to be not, that those 2 votes were separate and not independent interdependent on one another, they likely wouldn't have voted in the affirmative. The only other procedural course we would have had to do at that time was consideration by paragraph, which all the language that we were talking back and forth in discussion about intended that that was the direction that we wanted to move. And in those cases, we still would have had to call the body to vote in order to consider by paragraph. Then we would have debated the race portion, and we would have debated the percentage portion. And then when we were done with that debate, which we all understood what we were voting on, then we would have called a vote on the single motion, taking both of those components into consideration. We did neither, unfortunately, as a body. And then when we went to vote, unfortunately, the vote at hand was not restated. Debate was quelched. And I remember even looking at my fellow commissioners going, I don't even know what we're voting on. So I voted negative when I actually want to see this as the executive race. So we have continuity now amongst our three forms of being able to change something. So I voted in the negative, which is why in my con statement, the one piece that I did not know, which I wish I would have clarified better when I made my con statement, is that I indicated that if we just defaulted to the 15%, that's why I can't agree on this. When in actuality, if we would have voted, we did the comparison by paragraph or consideration by paragraph, it wouldn't have mattered. If we couldn't have voted on, if we couldn't have agreed on a percentage, then it would have, the whole vote would have failed. So my concern with bringing this forward has no bearing on anything that Commissioner Redding, you mentioned. It was purely because we were in procedural error, and I as a body would like to go back and correct that. So I put a recension so that we don't push something forward that was procedurally inaccurate and another amendment to the voters. I think it's a waste. I think we should do the right thing.
Jordan.
Thank you, Madam Chair. I just really want to state for the record that our by the rules that we have adopted for ourselves, it is improper for us to arraign or impugn the motives of other commissioners, and I do think it is critical that we, as a body, for our functioning, assume that we are all coming to this work with the best intention. We are all coming to this work with the betterment of our community at heart. The second piece of my comment, it's really more of a question for staff council. Is it your opinion that the vote that was taken on Amendment 13 was improper, or that the status in our packet of Amendment 13 as having been approved is inaccurate?
So my view of what happened with Amendment 13, and I've watched the video many times now, is that the motion that Commissioner Redding brought forward was a motion solely to amend the percentage. It was not the motion as written in the packet, rather a motion just to amend the candidate election, changing it from gubernatorial to county executive. But that was what was on the table because that's the motion we made. But the percentage was never put on the table for debate by the body. We were only talking about the motion to change the election. Then the vote was taken, that passed clearly. I believe there were some irregularities, which I think contributed to the confusion and where we are today. There was a lot of discussion by the body prior to a motion being made, which is improper and added confusion. We started talking about percentages at that point before Commissioner Redding ever made a motion. As indicated, the end before the voting was a little rushed. The motion was not restated at that point in time. There were procedural issues there. My read of Robert's rules is that points of order have to be raised at the time of the breach, or the point of order is waived. Nobody raises such a point of order during procedures. And as such, the vote under Roberts would stand, as even motions done in violation of procedural rules are not improper and void unless they also violate some sort of local, state, or federal law. So I don't believe that every aspect of the procedure was done 100% correctly, but I don't believe it would be proper to rule it out of order at this point in time.
I don't feel like I spoke quite articulately enough the first time, and I feel like, it's important to clarify that I would also like to register objection to overturning or rescinding that vote as invalid based on the list of things that you've mentioned. I think, to me, from my perspective, what happened in that meeting was, I think we've gotten used to it now, but we were with no microphones and we were in a library space. And we were having trouble figuring out and following what was going on. And we were earlier on in our series of meetings to where we were, everyone was asking questions about procedure and trying to figure out what was happening. And so my interpretation of what occurred was that our chair clarified motions and kept clarifying motions for folks. That is my recollection, so that by the time we were voting on this, I did understand because we asked the chair to clarify the motion. And I also remember that we had a packed agenda, which is why we moved along. And I think as we've seen in all of our agendas, it's the responsibility of our Madam Chair to keep us moving and on time. And so that is my perception of this, and I just want to add that to the conversation, because I think where one commissioner asserts that, well, we were rushed and this was somehow improper, I didn't see it that way at all. I felt like we were moving along with our agenda, and I felt that the motion was restated, and I understood what I was voting on very clearly. So I just want to.
Go ahead. Yeah, I just didn't want to let it pass either without my own self speaking up and just saying that, like, I'm extremely uncomfortable with people attacking motives, you know, we're moving forward, but I just didn't want to like sit silently and not say that my own self as well. It just doesn't feel right. So that's all.
Commissioner Ordos, can you restate your motion, please?
I do have my hand up.
Oh, go ahead, Commissioner Almas. It's hard to distinguish. Go right ahead.
Well, first off, I have to apologize because I'm not any better than anybody else in this room. But I think if you took the experience in this arena, this type of meeting, you could take the experience of everybody else here and mine would eclipse it. That doesn't make me better. That just means I understand the process. And I've been over backwards to not try and create problems for Commissioner there, for our chair. I tried to insert using shorthand. When I say bifurcate, I don't mean that needs to be the motion. I'm talking about splitting an issue. I did try to get more specific on this particular one, but as it relates to tonight, what we're dealing with, there was only one appropriate way to handle this once you accepted Mr. Redding's comment, and that was to immediately move into a committee of the whole so that we could discuss this. Most of the discussion tonight is not germane, not even germane to the motion of Commissioner Ordos. And that is whether or not we consider this. The only discussion, Madam Chair, that you should take is whether or not the notice was sufficient for it to require a simple majority or require 2/3. That's the only question that should be discussed following her motion. As it relates to the night where this took place, the reason this is out of order and the reason that our legal counsel is incorrect, he's skirting the truth. He's coming very close to it, but the bottom line is we did not move to suspend the rules. And so that's the one thing that would have allowed a consideration of just 1/2 of the amendment that was proposed and on our agenda. That was one way. The second way was to divide the question, and it should have been ad seriatim. As I mentioned in the situation, it should be piecemeal. And when I suggested that, you said, your response to me is it's a very good suggestion. That's what we're doing. That's what was said. So you think I like wearing these stupid things and looking like a deaf mute? But obviously I didn't hear your very soft-spoken, sweet voice, and I didn't hear that you did not get the question divided. That was my assumption. And that you could tell that from reading this whole situation, because as Andrew then made the motion, that's the other portion of the problem, his motion should have been before all the discussion. So all of us that talked about things other than what his motion was, were out of order. We were not speaking germanely. We were concerned about, and why were we concerned? Because we didn't understand that it was simply a portion, a part of the vote, 1/2 of the issue that was before us. That's why people kept saying these things. Now, an experienced chair, and you weren't experienced, so that is reason to understand how the problem arose, would not have allowed that to happen. And there were 2 or 3 steps that they would have taken to make it clear. And probably by the next time you do this, you will be assertive enough and have learned enough about that to not let this type of thing happen. But it happened that night. And the reason I know it happened is I was sitting next to Andrew telling me you don't need to have a number, because I knew there was a second part. When I got reamed out for people for voting in favor of the idea that we would change it from gubernatorial to county executive, I said to all of them, we haven't taken the second vote. I repeatedly stated that to them because I was totally in the position that that's where we were. And since my vote was the one that kicked it, gave it the 10 votes, I would have to tell you that my vote would not have been that way had I understood that the chair was just going to go on.
Commissioner Ellenboss, I appreciate all of this. We're well past time, and so
Yeah, but
I think the piece
this is
that.
what happens each time I try to clarify. This is why I've kept my mouth shut so many times. You know, when we go on through something.
Okay, can you wrap up your point, please? I've been incredibly patient with you, Commissioner Ellenboss, and I've heard what you said ad nauseum, but I'm asking if you could wrap it up because we're 30 minutes past time on this. Is what I wanted to ask you when you interrupted me was, you were there that night, and it's not on record that you called it out of order that night. And so what's hard for me to understand is, in your righteousness in this issue, why did you not bring it up that night when it would have been proper in the Robert's rules to do so?
Well, I'll give you a little lesson. Our actions of that night are not formalized until we consider the minutes of that night to see what the scribe has established. And if you recall, at our next meeting, when its approval of the minutes came up, I brought up all of these points and suggested that it was out of order at that particular point. And I will, with all due respect to the council, if he will go back and review that, the formalization of any action of any group does not take place until the minutes are considered.
Point of order, have the minutes been approved?
Yes.
Okay, let's move on. I call for the order of the day.
Okay.
And that would be, Madam Chair, only a single vote on.
Yes, the question of relevancy you asked, which I appreciate and I agree, is whether or not enough time was given. And I'm not sure if that is something that's stipulated or if that's just open to interpretation on this notice. So we know what number.
I couldn't find clear guidance in Roberts, and maybe Commissioner Ellenboss has that for when prior notice is established. It's clearly established, it's listed in the document that calls the meeting, it's listed in the agenda that just came out today. I think it's a determination for the chair to make.
Okay, so I think it's clearly an important issue to a lot of people on this commission, and so I'm going to allow this vote to go forward, and I hope that we can stay on task for the rest of our meeting.
If I may, Chair.
Yeah.
The notice difference, it determines what vote is needed to pass the motion to rescind. The motion to rescind can be made without notice, but it would require a 2/3 majority. With notice, it requires a simple majority.
Well, I don't think that we could say that there was no notice if there's no ruling about how much time there was notice.
I'm just making it clear that the result of that is the votes need to pass it rather than whether or not it's properly before the body.
Yeah, that's tough.
Point of clarification, are you saying that, regardless of how much notice, if there isn't notice, then it would require a certain?
2/3.
Got it.
But there was notice, so, we're gonna go ahead with a vote,
Is this a vote to put this on our agenda to vote on, or is this the vote to rescind? Just want to be clear on that.
well, I think, Commissioner Ordos was clear on her motion, but go ahead and reread your motion, please.
I move to rescind the commission's previous action regarding proposed amendment 13. The vote that occurred addressed only a partial component of the amendment according to our adopted rules and what was included in our agenda, and the remainder was never debated or voted on as intended during the body's discussion. The procedural oversight invalidates the assumption that the entire amendment passed. I propose we correct the record and readdress the full language properly following consideration by paragraph, or if it's the will of this body, Amendment 15 or Amendment 19 can serve as a substitution if the vote passes. Whether this passes or not strikes at the heart of our parliamentary integrity under Robert's rules, and I ask my fellow commissioners to support the motion to rescind so we can move forward with clarity.
Staff, would you please call the roll?
Eamon Collins,
No.
Liz Darrow,
No.
Joe Ellenboss,
Yes.
Lindsey Graham Ellenboss,
Yes.
Colton Kaltenfeld,
Pass.
Brad Kelly,
Yes.
Maya Morales,
No.
John Mutchler,
Yes.
Hannah Ordos,
Yes.
Joel Fitzjordan,
No.
Andrew Redding,
No.
Jessica Rinstra,
No.
Rod Stump,
Yes.
Jennifer Wright,
Pass.
Doug Chadwick,
Yes.
Colton Kaltenfeld.
Yes.
Jennifer Wright.
Yes.
And that motion passes 9-6. Are there any other amendments to today's agenda?
I move to just put this single pager that I passed out, for consideration at the very end of our agenda. It's something we've talked about a lot already, so I don't want it to take up, anything else's space. But just want to add that to the end of our agenda. This is a series of motions regarding amendment 16 and trying to possibly get final clarity on that, but I will happily save that for the end.
I second.
Is there any objection to doing this by consent? All those in favor, please indicate by saying aye.
Aye.
Any opposed? Great. Is there a motion to approve the agenda as revised?
So moved. Second.
Wait, where does this fall on our agenda?
I believe your motion said that it would be at the very end. I assume that would be at the end of old business.
Oh, no, I'm sorry, Commissioner Ordos is, where does that go?
I think that doesn't need more
It
time
doesn't
on our
change, okay,
agenda.
sorry, just wanted to clarify.
Okay. But what you're moving is to put this at the
Yes,
end of
correct.
old business, yes? Okay. Is there any objection? Wait, did we do all that? Any opposed? Yeah, okay, we're good. Adding that to the end. Good, good. We're gonna move on to public comment. So wait, we did that, okay.
Did we get a motion to approve the agenda
We did.
and that vote carried?
It was a consent, no?
No, you didn't consent. You didn't do that. That was for the previous item.
Oh, for Friday night.
Okay,
Okay,
in a second. I think
we need, so
Oh, sorry.
we just need the vote.
Could you clarify?
Let's do it again. Can I have a motion to approve the agenda as revised? Thank you. We have a second.
Second.
Any objection to approving this by consent? All those in favor, please indicate by saying aye.
Aye.
Any opposed? Okay, moving on. We're gonna move on to public comment. Members of the public may address the commission on topics related to the Whatcom County Charter. If you have a comment on one of the agenda items listed under old business, we ask that you hold your comment until that agenda item. So we're gonna start with general comments. Are there in-person commenters signed up to speak? Sandy Brewer?
Thank you, Madam Chair. Members of the commission, I'm glad to be back amongst you in person. It's something that I want to encourage you to do. I don't want to talk about what's happened in the past. But when we get down to those amendments that are obviously pretty much one way or the other, have a little confidence in us, the voters, to make a decision, and don't think that you have to think for us. And that's all I'm going to say.
Thank you, Sandy.
Those are all the people I have signed up in person.
Is there anyone signed up online?
Yes. First I have John Guerrero. John, please go ahead.
Yes, hi, thank you, and it's good to address all the commissioners. I'm gonna bring to you an issue regarding the ranked choice voting, if I could. And my experience is with ranked choice voting is up to about 3 years now with elections that are in my particular county. Not the whole county is ranked choice voting, just a few cities are, and I have been actively for about 3 years now engaged in election integrity, where I have been observing, the elections at our elections headquarters. In particular, what stood out to me was during the period of adjudication where the machine that does the counting can't figure out how the voter voted the ballot. It would go to what we call adjudication, where you get a couple of people and also another tiebreaker. They would look at the ballot and then try and determine what the voter, intent was. And what we've observed in several elections is that when it came to the ranked choice voting, that many more, probably double or at least in triple, the number of or percentage of the ballots came from ranked choice voting and not from the traditional ballots. Now, and it was clear to us when we were observing is that the voters were confused as to how to actually vote, which also confused the machine when it was trying to count it. And it said, I don't understand this. Well, it's because the voter incorrectly filled it out. And although it seemed to make sense, from our opinion, that the voter didn't understand how to do it, but they tried their best. There were errors made, unintentional, but there were errors. And it seemed to us that it's just no amount of education actually would probably, rectify this, because it's done so infrequently. Like, your cell phone is actually very complex, but if you use it every day, you get the hang of it. Now, these ranked choice voting elections, happen every 2 years. And you go in and you look and you, oh my God, what do I do with this? And you think some voters actually think they know how to do it and been doing it wrong for years until, they get some other education and find out, my God, I've been doing it wrong. And so I'm just saying that ranked choice voting, although it has some merits, it does tend to confuse the voters. Thank you.
Next I have Misty Flowers. Misty, go ahead.
Good evening, Commission. Thank you for your time on these important matters. I would like to speak in favor of 2 amendments. The first amendment is Amendment 17. This is a total common sense amendment. We all know that the increase of housing costs are increasing homelessness. and restricting new housing. So it makes total sense that we would at least only be as restrictive as the state. I hope that you'll support this. The other one is in favor of Amendment 29, which is because when the people of Whatcom County file an initiative that's approved by the auditor and the prosecuting attorney, and then the signature count secures that initiative to be on the ballot, the council has absolutely no right to interfere with that and to interfere with the people's voice, no matter what that is. So please support Amendment 29 as well. Thank you.
Thank you. Next, I have Cleveland Harris. Cleveland, go ahead.
Indeed. Hello, folks. I don't think I signed up by accident. I just clicked all the buttons, but I'll say something nonetheless. I think in Portland, as far as ranked choice voting goes, I think we can look at some studies to see like the surveys that were done after voters participated in that election style, and 91% of voters said they understood it. So I think in regards to the concerns to ranked choice voting, I think those are valid. I think that we have to invest in education to let voters know how the system works, and as far as ballot curing and stuff like that, making it transparent so people know it. But I think that the diminishing what voters can understand what they're doing while voting, it doesn't make sense to me personally. We ask voters to vote for things like executive who manage budgets that they might not fully understand, or folks that will be interpreting or setting laws. And we don't say hey, that's too complicated for a voter to understand, while they're voting for the governor. So I think, though that's not a completely great argument for it, I just think that there's a constant diminishing of what voters can do. And I think we can understand how this voting system works, as well as understand how to, vote for county executive or any other position. So, yeah, it looks like I have a minute left. I don't know what else I'd like to say. I guess also I think the same thing applies to direct democracy and initiatives. I think making that barrier accessible by the public is important. I understand folks don't want it to be too easy per se, but I think that these things are going to the ballot to the voters to decide, and making it easier for folks to have their voices heard is only better. So I think processes like initiatives and even referendums can be important in our democracy, because it allows public officials to see what the will of the people looks like, and sometimes that's different than what's on council. So I think just thinking about that while we make those decisions is something I would think. And I'll cede my time, I guess. Thank you.
Thank you. Harry Eskridge, would you like to talk now during general comment or to a particular amendment?
I'd rather speak to a particular amendment.
Okay, number 17?
Correct.
Okay, got it. Next I have Tyler Bird. Go ahead, Tyler.
Thanks. Got a whole bunch of your agendas pulling up or pulled up here, so just trying to find the right one again. Sorry. All right, so I just wanted to touch base on number 34 for ombuds and number 30 for dedicated aides for council members. I'll start with the dedicated aides for council members. I've heard through these meetings and others, a lot of people that feel like council members aren't engaged enough or aren't able to get back to answering questions or respond enough, that there's a desire for us to do more things, whether it's to spend more time on the budget or more time looking into what's going on HR related and the likes, all the way to having town hall meetings potentially dedicated every year. So with that said, I think it's important to recognize that the council positions are written into the charter as part-time positions, and that every county that is our size or larger has predominantly full-time council members, but also aides and individual aides, at least one, in some cases multiple for each council member. Our county has grown a lot population wise in the last 10, 20 years, especially since the beginning of this charter and its formation. And I think we need to recognize that, hey, if we want to do more things, then the council needs the ability to do that and the support to do so, because council members desire that as well, as far as I'm aware. All right, with that said, ombuds, I wanted to be clear because I went back and listened to my last testimony on this, and I was like, I don't think I was clear enough. I do support this specific item. I especially like it with a sunset clause. I am not a big fan of creating new departments either. I really, as most of you know, greatly dislike the idea of spending any additional money, especially with where we are at with the budget right now. But there are some major issues that we've run into previously, and potentially some other things that might end up coming out or happening as well. And the ability to look into those and dig into those, I think, is important, especially as it relates to our staff at the county, that 1,100 plus employees that work there, and the issues that they're having that we as council don't get to hear about on a daily basis, but really only through rumors and third party, which is really unfortunate. And so having a resource for them to be able to correct those issues and look into them, one that they feel comfortable going to, I think is valuable. And having this where there's a sunset period, I think makes it something that we can work with and do as well. So finances is still a struggle with, but I think we can cut some other areas and figure out how to get it done. So leave it at that. Thanks, everyone. Appreciate your time.
Thank you. Those are all the speakers I have signed up.
Okay. We're going to move on to approval of the minutes for May 22nd, 2025. Any commissioners have comments or corrections on those minutes? I think this is the third or fourth time we've seen these come through. Seeing none, can I get a motion to approve the May 22nd meeting minutes?
So moved. Second.
The May 22nd meeting minutes.
They're not in the packet.
Oh, come on. It's the May 22nd. Yeah, they're in June 12th. We'll bring her back next time.
The minutes I keep giving.
That's right. Also not seeing the minutes from June 12th, so.
I did not include those because there was none that turned around.
I can see that for sure. We'll do it next time. Cool. Moving on to old business. We can hear public comment specific to each proposed amendment prior to the discussion. First up, we have proposed amendment 17 from Commissioners Elamos and Chadwick on housing construction regulations. Are there any public comments?
Yes.
Okay.
All right, Harry Eskridge, go ahead.
Good evening, commissioners. Can you hear me?
Yes.
Okay. I want to speak on the prohibition of regulations of, sorry, my dog is sitting next to me, that are more restrictive than state regulations. Starting today, I was drafting questionnaires for candidates relating to housing, questions that some of you in this meeting are going to be receiving in the coming days. These questions drafted as a result of new research and a ranking that Bellingham finds itself on, and it is no longer the best places to live. For cities with populations less than 150,000 people, Bellingham now ranks #1 for housing and affordability in the United States. 13 years ago, Bellingham declared a housing crisis. This was supported a couple of years ago by resolutions in Bellingham and Whatcom councils declaring housing and affordability a public health emergency. So how have we done? In 2021, Bellingham didn't even appear on this list. This amendment goes to one of the single largest components of housing costs, regulation. The University of Washington Center for Real Estate Research estimates that regulations on average add almost $200,000 to the cost of the median priced home, or nearly 30%. Some current examples of how this has played out with people that I know. An applicant recently applied for a subdivision in the county and had 4 options under state law to comply with wetland mitigation. The applicant offered voluntarily to comply, well, not voluntarily, but offered to comply with 2 of those provisions, and county staff unilaterally selected another optional provision that they knew the applicant could not meet. The initial decision was to deny the application, but the applicant is currently fighting that. Another applicant was required to go to design review, a review that resulted in a dispute over window shape and size that added weeks to the review. I also know that Whatcom County has tree protection measures designed to save tree canopy in a county that is nearly 75% treed. But this issue is gaining increased prominence with the Wildland Urban Interface Code, and similar to Bellingham's recent forestry plan and landmark trees, the estimate on the impact to housing and the land available for housing is estimated to reduce the estimated buildable lands by almost 20%. State law mandating the removal of other obstacles with future effective dates, for example, ADUs, saw Bellingham specifically reject the removal of owner occupancy on those ADUs, instead requiring it for another 2 years, a barrier that resulted in some ADUs not being able to be built. My research today brought me to a statement that struck home. It said, we need to decide what our goals are, removing barriers to affordable housing and reducing housing costs, or by regulatory means condemn an entire generation to government, big banking, and Wall Street investor serfdom. Executive Sadu has called for bold housing action, an action that's reflected in Bellingham Mayor Lund's housing executive order. The best step.
The time is up.
Okay, thank you.
Are there any other commenters on this amendment? Okay, would either of the sponsoring commissioners like to speak to this amendment?
Well, I'm glad Perry called in. I think we all heard what he had to say, and that was pretty indicative of where this is coming from. So I'm gonna just elaborate on that I did start with Commissioner Chadwick months ago with a much more robust version of this that's been consolidated as time went on. We acknowledged the input from Mark Personius at the planning department, made some adjustments there, and brought it down to what you see today with the 3 portions. They're open to adapting what people might be concerned about. I've talked to many of you and been available to answer questions to those who have asked, and just kind of want to see where people are, and if there's a version of this that would be more appealing, we're definitely open.
Commissioner Chadwick.
Thank you, Madam Chair. Just to add on what Commissioner Ellenboss just articulated, again, this is really hitting at the core of trying to make housing more affordable for those here in Whatcom County. And part of that is reducing the timelines necessary to get through the permitting process, because the longer that timeline drags out, costs just continue to go up and up and up. And then we find ourselves in Whatcom County oftentimes on the receiving end of permitting and other variances and requirements that are more restrictive than state law. So a lot of times we have conversations about trying to bring what we're doing here in Whatcom County in line and consistent with state law. And that's really what this is trying to do. And, recognizing that people are moving here trying to afford a home, whether they're building a home themselves, or maybe they're moving into apartments or something like that as a renter, and developers are running into these same delays and increased costs. So I would encourage commissioners to consider this. And again, it has been amended, and not trying to be so prescriptive about how planning and development does their job. Certainly they're the professionals, but just acknowledging that it seems here in Whatcom County that the permitting requirements and the timelines are more significant and more pronounced than other counties near us. Thank you.
whether we have a motion.
I will move that we vote to approve.
I second.
Oh, goodness. Commissioner Morales.
I'll be very fast. I just wanted to know if you maybe could give any examples. So in item number 3, for instance, it says, I'm just gonna read that whole paragraph out loud for the public, because they don't have the packet necessarily. Ensure all departmental policies and administrative manuals related to land use and development do not contain any administrative rule, regulation, policy, or mitigation measure which, and then this is the part I have a question about, has not been explicitly authorized by county code, state, or federal law. I'm just curious if you have any examples. Like, could you give us an example of an area where you're seeing rulemaking that is not already something codified in those sets of laws that concerns you?
I'm going to defer to Perry's example of the applicant who went through the entire process and they came to a point where there were 4 very acceptable legal options. And there was a recommendation from planning department that out of those 4, the applicant wasn't able to go with the 2 achievable route, that they had to do option 3, which was not attainable.
Can I respond to that, Chair? Sure. Just to clarify the question more, my concern isn't so much always single family dwellings, which I think that's a great example of a home and a homeowner issue. But I'm wondering, like, how would this impact bigger developments? What do you see as being any issues that might come up there? Do you have any examples?
The same, I mean, it's similarities.
Before I became an overpaid refinery worker, as Joe called me, I was a home builder until 2010. What can really set you back is delays. If you're planning on getting something started in spring to get out of the dirt in the winter and you get delayed all summer, now you're in the muddy season, you're almost probably delayed another winter before you can start going with all the new erosion control laws and everything like that. So those delays that are above and beyond what the state requires, it could be really costly to developers and the project itself.
Commissioner Redding?
Yeah, I very much agree with the motivation behind this. As far as what Barry Eskridge said, it's virtually identical to my platform for Bellingham City Council. We have serious problems in how we're dealing with housing, very serious problems. And Barry did a good job of summarizing them. Nevertheless, my feeling is that this is a legislative matter, just like when I'm running for city council, this would be legislative. I'm not trying to get it in the city charter of Bellingham. It was brought up that the legislature voted unanimously for that. That could mean, and that was done as legislation again. It wasn't proposed to put that in the Constitution, which they could well have done with unanimity like that. So I think this is a policy matter. I have not seen, we have 7 members on the county council. As far as I know, not a single member has proposed this at the county council where it really should be brought up, in my opinion. I'd be more sympathetic perhaps if it had been brought up in the county council and it failed there. But I just don't think, for me, it's just a question of, what is constitutional in nature and policy to me is not in general. And the constitutional stuff is the structure of government, which is a different matter altogether. So that's why I'm not going to be voting for this, even though I agree with the basic principle.
Commissioner Caulfield, then Commissioner Chadwick, and then Wetchler.
Yeah, thank you. And I share some of the hesitations that Commissioner Redding shares. I agree with the idea in principle, and I love where we're going with it. I just feel like to some degree it's a little too prescriptive, especially the second and third point. I feel like largely what isn't already, some of that's kind of already done, so there's some redundancy there, but I also feel like we're wielding a very big hammer with these, and I'm a little bit worried about some unintended consequences. But the first one, I suppose, is, makes a little more sense to me. And, you know, I've had an opportunity to speak with, some of our council members, related to this, just to kind of help understand, their thoughts. And, my understanding, I'm curious to hear, Commissioner Redding's, because my understanding that, Councilmember Ellen Boss, Donovan, and Scanlon have worked on a resolution regarding the comp plan update to sort of address some of these, and specifically called out the issue of, you know, their administrative agencies making rules that aren't backed up by code. And my understanding that they want to continue doing that work, and it would be my preference to see that work done through council, where we can kind of balance the stakeholder engagement and make sure that we're not breaking things. So with that, I would like to make a friendly amendment, and see if this is a little more palatable for everyone here. I would like to strike the second and third items altogether and amend the first portion to read, to reduce compliance construction costs related to land use and development for housing. The county executive shall publish an analysis of how land supply and construction costs could be affected before amending any land use or construction section of the county code. Specifically calling out the county executive because the language as it currently stands, it's a little unclear who actually is publishing that report. I would guess that it would be the executive overall, because they have the staff and the manpower and funding to actually make that happen, and our council certainly doesn't. Now, we have some bills amendments later on that might work with that. So just want to be really clear that it's the county executive shall publish, just so we're not breaking things, I guess. So I would hope to have that be considered a friendly amendment.
Are we able to continue discussion while I consider?
Yeah, I just want a clarification on whether that amendment will be considered friendly, not that it's unfriendly, but is that a substantive change that would need to come to a separate amendment?
That's the motion to amend. Doesn't have to, as long as it's a second.
Second.
Okay. You have a clarifying question?
Yeah, were you, just to clarify, were you saying that you were or were not sure that that would be the county executive role?
With the language as it was presented to us today, it's unclear. And I know that that's some feedback I had from members of council, is that was unclear. So I just wanted to specifically call out the executive to make it
Meaning it is
crystal.
currently the county executive that says these.
Well, it's not happening, but
But it falls under, I was just gonna say, if we
theoretically,
could change this to county government, we're unsure and we don't know, but
yeah, I just figure it'd always be more appropriate for the executive branch, because they're the ones that have the legions of staff that are doing this type of work. And if they need a contract out, they don't need a contract out. But
Let's see, we have a whole queue. No, it's okay, Commissioner Chadwick, go ahead.
Thank you, Madam Chair. Again, Commissioner Coltonfeld, I agree with you. I think it should fall with under the executive's office. As part of that discussion we had about clarifying the roles of the independently elected officials, and we broke down the executive branch. Plan development clearly falls under the executive branch. They don't have their own elected officials, so they would fall under the executive's office. So that would make sense to me, is who would be responsible for that, because they ultimately have direct oversight and direction of that, the Department of Planning and Development. And then secondly, you asked a question about examples. I had spoken with a developer, and one of the concerns and frustrations was a lack of consistency or clear expectations, and some ambiguity in how things were being interpreted depending on which staff member you talk to on any different day. So that's some of the language that was put in there about specific, showing the specific language. If you're going to be more restrictive, provide the rationale and the specific language that supports that. But I understand now some of that language has gone away, but I appreciate the intent and the amendment that was put forward by Commissioner Coltonfeld.
Just for clarification, it hasn't necessarily gone away yet, but there is a motion to strike points 2 and 3.
Madam Chair, briefly, the problem is we have a number of departments in this county that are out of control and make their own rules.
Thank you. I'm going to stop you there. We've got Commissioner Mutchler. Go ahead.
I think this is bold and courageous. I also appreciate Mr. Eskridge, who's been a longtime advocate for policies to make housing more affordable. I've had the privilege of building 2 homes for my family, otherwise we would be probably somewhere else. In fact, I think Mr. Eskridge spent a day with me one time about a dozen years ago, helping me with my home. So he understands the issues. This is a great idea. What we're doing now is not working. It's not working in Whatcom County, it's not working elsewhere. We really do have a housing crisis. The idea of modest income families affording a home, I don't know how they do it. And I have 2 questions about the proposal. This is just for unincorporated Whatcom County, I assume. It's not for the incorporated cities. Okay, correct. And then the other question is, does this require a scrubbing of all existing policies based on what the current state expectations are? Is this just going forward to new policies?
I don't, I think from this point forward would be my expectation.
One second. Just a clarifying question. Is it clear in here, and I missed it, that it's just for unincorporated, or is that something?
The plan department only issues permits to unincorporated Whatcom County, and that's, yeah, sorry, that's kind of where
Every
it's coming
city
from.
has their own
This is
planning
one of those
department.
differences, so if you're in unincorporated Whatcom County, you're planning development, Whatcom County handles your permit application. If you're in a city, that respective city handles your application.
Thanks for that clarification, Commissioner Wright.
I just was wanting clarification from council about referencing platforms and campaigns during a meeting and whether that's okay. I don't know if there's something clear.
I don't know the answer to that offhand. The rules are, I suppose it would be advisable to avoid that. I'll get some clarity on that question.
As a precedent, we've asked for folks who are running for a separate office than this one we've been elected to right here to not campaign in this space. Let's see, where are we at here? Commissioner Ordos.
I'm not sure if we have a county council member still listening to our meeting, but I believe the scrubbing of code is something that they're systematically have been taking on, I think, for the past year or so. So they're kind of moving through code and updating and taking out language that's no longer applicable. So I don't, like I said, I don't know if there's a county council member that's still listening that can verify if that's true, but to the question.
Point of order, Madam Chair. I think the only thing, good things are being said, but they're not necessarily germane to the proposed amendment. Discussion now should only be about the amendment to the amendment.
There. Commissioner Collins, is your discussion point about the amendment to the amendment?
Yes.
Go ahead.
I had to think for a second. I guess I'm wondering on point 1, publishing a credible analysis, if it's requiring a credible analysis before any amendment to land use or construction section of the county code can be made. I guess to the authors, are you concerned that that could slow down reform of the county code too? Like even if they're making the code less restrictive, I'm a little nervous about putting another like administrative barrier in there, knowing how long an analysis from staff could take.
Short answer, no. I did ask that same question to make sure it wasn't an unintended consequence and was assured that, and I don't see that being something to be concerned about. I don't know how to. And that's kind of why we left it fairly vague, how that can be determined, what that could look like. So it can be actually a process that's in place and easy to update and refer to when needed.
I was just wondering if you could restate the content here, because I've lost it in this discussion and I'm not sure what I'm voting on.
For sure, yeah, so I will restate it. So I'm going to strike provision 2 and provision 3, the provision for that prohibits a permit applicant from being required to use administrative rules. Basically, everything from that point on is struck so that the amendment only reads to reduce compliance and construction costs related to land use and development for housing, comma, the county executive shall publish an analysis of how land supply and construction costs.
Slow down a little.
For sure. To reduce compliance and construction costs related to land use and development for housing, comma, the county executive shall publish an analysis of how land supply and construction costs could be affected before amending any land use or construction section of the county code.
Commissioner Wright, do we know how much it would cost when chairing the task force? We did some different analyses. We had to hire outside consultants for that. And it was time consuming and cost a significant amount of money. So I'm just curious about that.
Right, so the intent here would be an internally provided analysis. And that could be, I guess, adapted. If it's not working that way, it could be broadened, but it wouldn't anticipate an additional cost.
Commissioner Elbas?
Yes, I just wanted to state that you open your charter and you look to the portion about no regulations shall be considered prior to the county council assessing the impact on any particular individual and presumably creating a form of compensation for that. That's what opens this whole concept, contrary to the position Andrew stated. That's what makes this. This is a continuation of that. It's a more definitive way of describing via a specific practice that things do comply with the law and don't exceed that of state requirements. And that's an ongoing problem in Whatcom County, no question. So specific to the proposed amendment, I would wonder if it becomes redundant in the light of that, or maybe it should instead refer to charter amendment, the charter amendment that talks about that. Because in concept, bear in mind that a lot of things happen for the public good that might be particularly pricey to either an individual landowner or a developer or even a governmental agency. All of these things need to come into play. So consistent with what you're attempting to accomplish by your amendment, take a look at it from that perspective and see if it might already be covered or should it be referred to the intent.
Commissioner Mushler?
Thank you. I really appreciate the commissioner's amendment because I think the intent is the same direction. My concern though is I don't see how the county executive would fit into this amendment because it's the county code that would be decided and voted on by the county and then signature of the executive. It seems like we're way down the path by the time the executive gets it. Maybe I don't understand what we're looking at here, but it seems like it's the county that should be doing this, the county council should be doing this. And then eventually the executive can sign off. And his job is to execute it, to make it happen. So it puzzles me that we put the executive in this thing here. Not his role at this point.
I want to raise one more question, just to clarify. Even with this amendment, I guess I would want to understand whether I was voting on something that would essentially supersede us from creating any stricter environmental controls, protecting wetlands, protecting forests, anything like that, water quality stuff. I think that is my main concern here, because I do want to make permitting and building and expanding our housing supply much easier, but I also don't want to trample any efforts to like protect our drinking water so we have it, right? Like things like that. So I just wanted to clarify if anyone felt that that would be a problem.
That was a leading question from the very beginning. No, the answer is no. Those things are absolutely prioritized. This is way below that. This is at the point where we've gone through all of those measures and complied with everything that needs to happen for environmental policies, for mitigation, for laws, for codes, and are at the point where there's an administrative ruling that is not defined, making it so the reference is to what has been defined.
Mr. Muchler.
I'm good.
Okay, Commissioner Jordan.
Thank you, Madam Chair. I just, I shared similar concerns originally about the descriptiveness of the original amendment, and just want to ask for you guys vote on this amendment to the amendment to bring it back down to the credible analysis. I think for me, this makes it generalized to a point that it is something that I'm comfortable with being in the charter, and I think simply gives the county council the information that it needs to be able to make these decisions. I very much find it akin to the environmental impact statements, the economic impact statements that happen at the state level.
We have an amendment to the amendment.
Clarification, did we amend the county exec to county government?
We're leaving it at county exec.
I feel like it's appropriate for clarity's sake.
Right.
I would just say that with what we've done, it would be absolutely the executive staff doing it, but it's like the tragedy of the commons. If you don't say who, something that belongs to everyone, nobody takes care of it. So if we want it done, just say who should do it. And that is who would do it and should do it, even if we think the council should. It's just how the county government operates.
Would be my reasoning for that is, a future executive or whatever, I could see a situation where we wanted, or the council would say, all right, can you do this? And he's like, what? And the executive could just be like, well, that's in your court, right? And now we have the situation exactly where no one wants to do it. So it's better to just spell out exactly, just so we're not.
Mr. Chadwick.
Thank you, Madam Chair. I think just to clarify for Commissioner Mushler, I think the intent here is the county executive will direct his staff to produce the work product that will be reviewed by the county council to make their assessments of what needs to change in the county code to make this more reasonable and efficient for the public to actually move through the process and hopefully lower those housing costs in the future.
Fair enough.
Stephanie, please call the roll. This is on the amendment to the amendment. A motion to strike provisions 2 and 3 from amendment 17. And to change, to add, county executive shall.
Was all the words that you changed?
Oh, we do want to restate.
Go ahead and restate it. Let's hear
Okay.
it.
Yeah, I would like to motion that we amend the amendment 17 to read to reduce compliance and construction costs related to land use and development for housing. The county executive shall publish an analysis of how land supply and construction costs could be affected before amending any land use or construction section of the county code. Further, we will strike section 2 and 3 in their entirety.
Liz Darrow,
Yes.
Joe Ellenboss,
Yeah.
Lindsey Graham Ellenboss,
Pass.
Colton Kaltenfeld,
Yes.
Brad Kelly,
No.
Maya Morales,
Yes.
John Muchler,
No.
Hannah Ordos,
Yes.
Joel Pittsjordan,
Aye.
Andrew Redding,
Yes.
Jessica Rienstra,
Sorry. Okay. We'll come back.
Rod Stump,
Yes.
Jennifer Wright,
Yes.
Doug Chadwick,
Yes.
Eamon Collins,
Yes.
Joe Ellenboss,
Abstain.
Lindsey Graham Ellenboss,
Yes.
Jessica Rienstra,
Commissioner Renshaw, we cannot hear you. wondering.
Sure, so we'll be back at 7:30.
Oh, okay. Commissioner Reeser is excused. And that passes.
Madam Chair, please, will you clarify what that vote was before?
Yes. This was an amendment to proposed amendment 17. And that motion was to strike provisions 2 and 3 and to change the language in the beginning to include the county executive shall.
So those to accept an amendment to the initial amendment. Thank you.
Yes.
Point of order. Were you about to announce the tally?
I was.
I think there's some passes. Would you?
We got it. Oh, they came back through.
Oh, did they come?
Yep.
Yep.
We've got 11
Thank
in favor, sure. 2 opposed, 1 abstained, and 1 excused. Okay, Commissioner Fitzgerald.
Thank you, Madam Chair. I wholeheartedly am asking for a yes vote on amendment 17. I really appreciate the good work of the good members from District 5 and District 3 on this amendment proposal. When I think back to a lot of the conversations with folks from my district, I think one of the things that they asked about the most is there anything in the charter that can help with the housing crisis? It's something that even though the amendment specifically would not apply to housing construction in District 1, it is a district in which vast majority of renters cannot afford their rent, and a vast majority of homeowners cannot afford their mortgage. And I think it is something that's incredibly critical to this community, and especially given the additional information that we got in the last week or so, that the Economic and Revenue Forecast Council has further revised down their expected housing construction over the next 4 years. So I think it's great to be able to give the county council the information that they need, and would commend the work of both of the commissioners who brought this forward.
Commissioner Rainey.
Yeah, so this essentially gets rid of the legislative portion, so I'm going to support.
No further comments. Staff, could you please call the roll?
Joe Ellenboss,
Yes.
Lindsey Graham Ellenboss,
Yes.
Colton Coltville,
Yes.
Brad Kelly,
Yes.
Maya Morales,
Yes.
John Muchler,
Yes.
Hannah Ordos,
Yes.
Joel Pitts Jordan,
Aye.
Andrew Redding,
Yes.
Jessica Ranstra, Rod Stump,
Yes.
Jennifer Wright,
Yes.
Doug Chadwick,
Yes.
Eamon Collins,
Yes.
Liz Darrow.
Yes. And that passes 14 in favor and 1 excused. Moving on to proposed amendment 19 from Commissioner Ordos on signature requirements for putting charter amendments on the ballot. Are there any public comments on this amendment?
Yes, Sandy Brewer.
Madam Chair, Commissioners, I think that while we want to make it hard for frivolous amendments to be put forward, by the same token, using the signature total based on the county executive's election rather than the gubernatorial election, which would be lower if I'm not mistaken, is a good thing. Because we're worried about our county charter, and we're worried about the people who vote in our county election. To tie that to all the people in the state, and we have to match a percentage of their totals, seems to just run counter to logic to me. So I want to thank Commissioner Ordos for coming up with this, and I urge you to vote yes on it.
Thank you. Those are all the speakers that have so much.
Okay. Commissioner Ordos, would you like to speak to your amendment?
Yes. So originally, there was some verbiage in here that now no longer applies because it's not in any way connected with Amendment 13. What the intention of this amendment is to take a few things into consideration after listening to everybody's comment and the discussion we had earlier. One is to move the gubernatorial race to the executive so that we have consistency amongst all 3 of the ways in which changes can be made within charter referendums and initiatives. but also a percentage that originally my proposal was, I threw out the number 25. It's a nice round number, but I threw it out there with the intention for the body to discuss what is considered a reasonable number for charter amendments. One of the numbers that was thrown out at our last meeting, 25 was 2% above what we currently have. And I understand there's argument to be made that we want this to be a threshold that can only be received if there's broad support across the entire county. And 25 would really just keep us where we're at. I believe the percentage that Commissioner Amons put, that was an exact number, was like 23.7%. I don't necessarily like that number because it's not a round number. But what I would like, I would actually like to modify, if this body is okay with that, not 25%, but 22%, which is a reduction in what we currently have, so that we are lessening that barrier, but still maintaining a reasonable threshold. And as I explained in my rationale, 22% is still at the very, very low end of our nationwide standard, which if you put it on the executive race would be 20 to 35%. That's the standard in the nation. The only other charter county that has the executive race is Pierce. They're at 20. Other than King County, the rest of the charters are 15 to 20% of the gubernatorial. So we are still at the with 22%, we're still at one of the lower standards nationwide and the second lowest of our charters within Washington state.
Second.
I'm sorry, I missed the motion. I caught the second.
I assume that was a motion.
I didn't write all that down.
I suppose the motion would be to, oh goodness. The motion would be to have the required signature percentage to be 22% of the executive race.
Second.
Point of order, Madam Chair. While I'm in favor of that, technically you can't do that because what's on the agenda is 25%. The appropriate thing would be to move 25% and executive race and then amend it down. Because the only thing before is what's on our agenda.
Would the commissioner accept a motion to approve proposed amendment 19 and send to the voters and then further amend from there?
So are you asking me to present it as I originally intended with the 25%?
Yeah, just to get that motion out there to honor the agenda, yes.
Yes.
That's what it was.
Yes.
Second.
Okay, good. We have Commissioner Redding. Well, okay, so Commissioner Orvis has moved that we approve proposed amendment 10 as written so that we can get 19, wow, that's random numbers. To honor the agenda, and then we will need a motion to amend that, Commissioner Redding.
Yeah, I want to make a motion to amend to 18%.
I'll second that.
Okay.
Can I just ask a point of clarification? The numbers in the chart on page 17?
Yes.
You have the to use for the examples above numbers.
Hold on 1 second.
It's a little loud.
Just give me a second to.
The door's open.
Yeah. I have kids, you think I could be able to block it out, but this one I cannot.
So it says, in this little box, there's sort of a key, and it says to use for the examples above, recent gubernatorial votes in Whatcom, recent exec votes in Whatcom, and I was just wondering what year that was.
I believe that was the last gubernatorial and the last executive.
Okay, so our most recent year.
Yeah, yep, the most recent numbers I can find. Yes.
Okay, because sometimes that matters in vote numbers.
Yep.
Yeah.
We have a motion to amend the percentage number and amend the proposal 19 from 25% to 18%. We have a motion and a second on that. Commissioner Ray, go ahead.
Were you allowed to amend amendments? I remember when Commissioner Muchler did that one time. I think we can.
I don't think we want to step in this same puddle, so I'm gonna say no. Let's finish this one up and then get back to it.
We can.
We can go out, kick it out to level 3.
All right, okay, so I can amend the amendment, and that's allowed, okay. So then I would amend the proposed change, the amendment to 22%.
22%? Oh, 22%, 22.
Second,
Commissioner Michelin?
I said second
Yeah.
to her amendment.
Yep, okay.
22.
Okay. Good. Can we get a roll call on that?
Okay, so what are we,
So-
which one are we voting on?
Okay, we're on the third level here. The motion is to amend the number in proposed amendment 19 from 25% to 22% of the executive election.
I can clarify that process for our record, because we need clarity. So basically, the original motion was moved at 25%. I believe Commissioner Redding offered the amendment to make the amendment to 18, and then there was an amendment on the amendment to make it to 22.
And this is a very good question, because if this amendment passes and the next amendment passes,
If this amendment passes, it amends the second.
This one's for to just speak, I would just say that, I offered that because it was presented to good as written, and then do the 22%, so just trying to honor that.
and I'll just say, not being an expert in procedure, it seems a little bit like that just stepped on the motion that was already on the table, which is probably why we can't do this any more than right here. It's a lot. But my understanding of procedure, please correct me, Mr. Allenboss, if I'm wrong, is that we're gonna need to vote now through these 3 amendments. And I think that's where my confusion is because if we,
I think we have a problem on the amendment to the amendment, right?
go ahead, Commissioner Rhodes.
I have 2 questions, council. One is, we have the original proposed, and then the amendment, and then the amendment to the amendment. My question is why wouldn't we present it as a friendly amendment? I'm confused.
I have an amendment on the floor to 18, so we have to deal with that, and so.
No, I was just wondering why that wouldn't have been presented as a friendly amendment.
No, I'm
Yeah.
happy to present it that way.
The friendly amendment still has to be voted on, it's just a descriptor of the intent of the amendment, it doesn't really change the procedure.
Gotcha, okay.
I think that if you accept it as a friendly amendment, though, and it fails, it's done, versus if you accept it as a hostile amendment, then we have to vote on all the parts.
Okay.
And to be clear, the amendment or amendments only need 50% plus 1. But the big proposal needs the 10 votes.
Mr. Custer.
Thank you, Madam Chair. I will just state that I'm gonna vote, I will be voting no on the 22% right now, because my preference would be 18%, but that does not necessarily preclude me from voting for 22 later on as an independent.
Commissioner Ray, can we do that tonight? Because don't we have to put things.
No, I mean like an independent to.
A separate amendment.
A separate amendment to the underlying proposal.
Okay.
Right, you could withdraw your motion.
Wait, I'm supposed to withdraw my motion?
You could if you wanted.
Okay.
We're still waiting
withdraw
for-
my motion.
We're still waiting for Kevin to see.
Presented for the second, so I think the body would have to vote on the withdrawal motion.
Commissioner Ordos, what are you waiting on Kelly for?
Wasn't he see the amendment to the amendment? I'm trying to figure out which amendment we're landing on. If it's Commissioner Wright's amendment and she was able to do that, then that would be
Yes,
the
right
motion
now.
that's on the floor.
Her amendment is on the floor.
Okay.
22% is what's being discussed now.
Yes.
I'm getting very confused. Can I make an amendment to that one to bring it back to 18%? Oh, okay. Jeez.
That was my confusion.
Yeah.
Yep, okay, good. Is everyone clear about, we're about to vote on 22% is the amendment. Everybody knows that's what we're voting on, so that we don't have to go through all of this again, okay? Cool.
Just to, for the sake of discussion on this amendment, I would like to concur with Commissioner Jordan, that I will be voting no on it because I would have preferred to vote on the First Amendment and then do it, just to respect everyone's.
Sounds good. Staff, could you please call the roll?
Lindsey Graham Ellenboss,
Yes.
Colton Caulfield,
No.
Brad Kelly,
Yes.
Maya Morales,
No.
John Mutchler,
Yes.
Hannah Ordos,
Yes.
Joel Fitzjordan,
No.
Andrew Redding,
No.
Jessica Rienstra,
No.
Rod Stump,
Yep.
Jennifer Wright,
Yes.
Doug Chadwick,
Yes.
Eamon Collins,
No.
Liz Darrow,
No.
Joe Ellenboss.
Yes.
That passes 8-7. So now we're back to the original motion to approve amendment 19 and send to the voters
I think we're in this.
As amended.
as amended.
Or to go back down.
I think that, no, the second level has just been finished. Is that correct? That's what you said, right? So that would need to be a separate
First
amendment
amendment is
now.
on the table now.
Just
For the 18, I believe.
Wait, what?
Right,
But the first one passed.
but then we have to.
The second level, but you're.
Yeah, we have to-
Second amendment.
Yeah, so then don't we vote on
Commissioner Redding's amendment was the first amendment. Now.
So we have to-
So
I thought it was superseded because it was,
Yeah.
I think it supersedes it because it was passed.
It was an amendment to his amendment.
Yeah.
That's-
So we're at 22.
So, I mean, if that's what Bobby's fine with.
I think we'd still, because Commissioner Redding's amendment has been amended to be 22%. We still have to.
We have a main motion now.
On that, and then go back to the main.
I would entertain another amendment if there is going to be one. As it is, the amendment 19 is set at 22% in that proposal.
For point of clarification, we are now voting on the main motion, right?
Should there be no other motion? Go ahead, Commissioner Morales.
I would just to note, if it doesn't pass, it just reverts back to the original charter. Just FYI.
Yeah, heard. Go ahead.
Just to clarify, it does seem like someone could now amend the 22 back to 18. Is that correct?
Yeah. We're somewhere in between. Commissioner Fitzgerald.
I will move to amend to 20%. I think that is the highest that I am willing to go.
Second.
Can those numbers be stated what that means?
Yes, so this motion is to amend the percentage number from 22% to 20% on proposed amendment 19.
But the numerical count, for example, what that would be.
Twenty percent is 16,409.
That's in Pierce County.
That's,
It's still the same.
Is it still the
Yeah.
same based on our numbers? Oh, sorry.
yeah, as of like the last time that people voted in that election, so it'll probably be higher than that slightly. Okay, go ahead, Commissioner Redding.
I just want to point out, the auditor is saying you need 25% more to get the actual ballot signatures, so that would buy about 20,000 signatures.
Maybe this is where we should include the recommendation from Stat Fall, require at least a minimum of 10% from each council district.
Sounds like the waters.
Okay.
Madam Chair,
Oh, go ahead.
I just want to make sure because I don't want to find ourselves in a situation that we just got out of. So I want to make sure that I'm understanding clearly. So now we're voting on amending back to 20%. And if that doesn't pass, then it's done.
We're at 22% was the last thing to pass.
And then we vote on 22%.
And we vote on the amendment as amended.
Yeah, so I think currently it's 15, let's see, currently it's still with the state, right? We want to get it to local. And with the state, what's the number with the state? Let me look.
20,862.
Okay, so this is essentially substituting and just keeping the numbers the same, right? No, or excuse me, it lowers it.
20% would lower it. Yeah.
It lowers it to how much?
16,409.
16, okay, so it lowers it considerably, right? 4,000 votes, which is significant. And I think we should make sure we're comparing apples to apples. So talking about like extra votes, doesn't seem super helpful right now, but I think the 20% lowers it significantly. Commissioner Mutchler.
I am so happy that Commissioner Ellenboss is here to remind us of what I thought was a hell of an idea by South Hall to do, to expect a certain percentage from all 5 districts. Because the big concern is you're just gonna get them all from the Northern County or being them all from South Bellingham. And can we think about that for a second? I know that we're tired and late, but I thought, dang, it's a great idea. That we require a certain amount from each of the 5 districts.
What is germane to this vote right here is to amend the percentage number from 22% to 20%. Commissioner Fitzgerald, go ahead.
I just threw it out from the standpoint that I could be
Sorry,
supportive of
totally out of
20%.
order, I realize that, but okay, go ahead, Commissioner Fitzgerald.
Thank you, Madam Chair. I just want to state for the record and just for commissioners' awareness as to like the procedure here. We had Amendment 19 with 25%. Commissioner Redding made a motion to amend Amendment 19 to 18. That amendment was amended to 22. We're not quite to the level of Amendment 19 yet. We've got the amendment where this current motion is still an amendment to the underlying amendment to the underlying amendment.
Yes.
That is how it.
Yes, we will have 2 more votes to go
Yes.
on this one.
Okay.
So this is just a simple majority vote.
And the number is 20%.
20% from 22. Staff, will you please call the roll?
Colton vote.
Yes.
Brad Kelly.
No.
Maya Morales.
Yes.
John Mutchler.
Yes.
Hannah Ordos.
No.
Joel Pitts Jordan.
Aye.
Andrew Redding.
Yes.
Jessica Rienstra.
Yes.
Rod Stump.
No.
Jennifer Wright.
Yes.
Doug Chadwick.
No.
Eamon Collins.
Yes.
Liz Darrow.
Yes.
Joe Ellenboss.
No.
Lindsey Graham Ellenboss.
No.
That passes 9-6. So now we're back to the original motion to approve Amendment 19 as amended and sent to the voters. And to be totally clear, this now is linking the initiative, the signatures required to pass the proposed initiative. Charter amendment, thank you, good grief. 20% of the executive, the last votes counted, cast in the executive race. Does that make sense to everyone? Commissioner Elmos?
Yes, Madam Chair. It would make me considerably more comfortable with that number if we in fact adopted the proposal that South Hall put before us. And that was that in signature gathering, it would require a minimum of 10% from each of the 5 council districts. So I would so move.
Second.
Commissioner Morales, go ahead.
So that amendment on that, I feel like that substantively changes this, but, so I think I might argue against that being, allowable amendment here. Because it breaks us into a district level situation that feels like it's not in harmony with this amendment. Yeah. I'd like to call for my counsel on that.
I don't see it as negating the amendment, just clarifying that's what they would be allowed.
Yeah, so in that case, I have a comment on that, which would be that, in that same memo, to us, with requested changes to our charter, our county executive, Suju did point out that, when you require a unanimous vote on the council, that it, means that a single person has veto power. And I conversely pointed that out about his suggestion to require percentages from all districts that you then essentially may allow one district to veto power over people's initiative. And so that is what I see as the problem with this, is that if a ballot committee for some reason could not reach that threshold in a certain district, that allows that district an outsized amount of power over ballot initiatives. And I think that they should be at large because that's how our charter really conceives of them. And so I would object to that.
Okay, just wanted to clarify, we had a motion. Did we have a second?
I made a second.
Okay, thank you. Go ahead, Commissioner Fitzgerald.
Thank you, Madam Chair. Concurring with the comments from the good member from District 2 and adding that given the fact that there is no precedent for this that I've seen any examples of, I will be asking for a no vote on it.
Commissioner Mutchler?
As I mentioned earlier, we have moved, 10 years ago, we moved 20% to 15% gubernatorial. That's a 25% reduction. This is another reduction. And we're not asking for 20% from each of the 5 districts. We're asking for at least 10. This is very reasonable and causes people who are taking signatures to have to go through the whole county. You know, and if you got a weak county, a county that's a district that's hard to get, maybe it's only at 10%, but 10% is not 20%. This is really cool, and I hope that we will adopt this. It's legal, as you heard from our council, and I think this is a great benefit to the entire county. It says we respect the whole county. We've been talking about this all the time, about this, about ranked choice voting, how this respects everybody. This respects everybody.
Go ahead, Commissioner Bell.
I agree with this. I think it's a good thing. When you look at our voting, just for this commission, District 5, we were single digit margins of victory, right? And Bellingham was double digit. District 3 was close. I think it's a great thing. I think it'd be really good. I think 10% in District 4 will be easy if it's a valid cause. I think people support it. I think it's a great thing that represents everybody, not just, it's not divisive. It includes everybody.
Commissioner Redding?
Yeah, I'm willing to support this at 20%. I'm not willing to support it if this amendment is adopted, because again, it will guarantee that nothing ever gets to the ballot, as has been our history for 50 years now, for the past half century, directly from the people. And I feel very strongly that there should be a reasonably viable way of getting ballots from the people to the people, you know, from signature gathering onto the ballot, because ultimately it's all the voters who vote on this anyways. So that's my position.
Madam Chair, I'd like to amend the amendment to 5% from each district.
I can't support that.
Madam Chair.
Commissioner Allen, let's go.
Yes, I'll direct my comments to you, but I hope Mr. Redden is listening. The goal here was to get this consistent and get into the county council races as opposed to gubernatorial. This motion accomplished that. The goal, likewise, as stated by some more members, was to bring the number down somewhat. Pretty significant decrease in numbers that are needed for the signature with 20% of the executive as opposed to where we are today. If this fails, we fail to accomplish any of the things that were the goal with your original proposal, Mr. Rick. So I would suggest we consider that, because a no vote on this, I'm pretty sure it creates a no vote, or at least not a non-achievement of the 10 votes to get it qualified for the ballot. And so I would suggest people think about that as they do their voting.
Commissioner
It feels to me like it creates inconsistency while trying to create consistency, because the others, it's not like a certain percent from each district. And it does feel like substantively different to me to be doing it for a certain amount per district. I live in an underrepresented district, and I can't support like something that takes us out of alignment when we're trying to get in alignment.
Commissioner Colville?
Yeah, I'm gonna push back on, this. Maybe there was merit to this idea. I'm still very skeptical that this is a good idea. But if this was something that was being seriously considered, I wish it had been brought up prior to this meeting, so that we'd have time. I mean, this is a pretty fundamental change, I think at least. And it's kind of thrown me for a loop here, because when I made my motion to rescind, I did so with the thought that we would be negotiating a number here that was based. I had no conception that we were going to reintroduce this. And so to me, I'm feeling a little blindsided by this. You know, and I don't want to prescribe intent here, but, you know, I voted to rescind because it was my understanding that the only reason that we had made that initial vote is because people were confused about what they were voting on. And I felt like we needed to, I owed it to this body to respect the intent of commissioners. And so I went on a limb. And with this, I'm like, whoa, we are in a totally different area than I thought we were even gonna end up at. And so to me, if the decision is either, oh, we're either gonna get nothing done, we're gonna scrap out and go back to where we were before at the 25 at the gubernatorial, or we do some compromise like this that I had never even considered, that's a really hard place to be. And I'm not comfortable being put in a situation where that's where we're at. So I would advise, you know, I made a good faith decision and kind of went out on probably an unpopular opinion to my colleagues. I would just like that to be respected.
Commissioner Rinstra?
Thank you so much. And thank you for those points, Commissioner Colton Phelps. I feel like this assumes that the districts are all equal, and it really overlooks groups that are potentially already underrepresented. If in my district, we wanted to put something forward about the floodplains and zoning and about how to protect housing moving forward, that may not be something that resonates as clearly when gathering signatures in other districts. That's just one example, but there are many. Ultimately, every single voter gets to vote on something when it is on the ballot. That is when they can thumbs up or thumbs down that. If someone is working on gathering signatures and lives in rural Glacier, putting the onus on them to go to every other district to find transportation, to find means and time to go and gather those signatures, it is harming the voters and the people. It's not harming the millionaires that come in and pay for signature gatherers. So I really have to push back on this as well. It's not upholding the ability for the voters to have their voices heard.
Commissioner Elbas?
Yeah, I just expect we're all big kids. And I made a motion to amend, and you all have the ability to not get upset about it, it's just to vote no. And that's part of what we're attempting to accomplish. It's a form of compromise, trying to get to where we feel comfortable. And if you're not comfortable, you just vote no. That's legitimate.
Commissioner Scott?
Is there a way to find out what the number is for the 10%? I mean, if we have to.
They're about 33,000-ish, I thought 34-ish thousand, so.
So are we asking for the 10%, is that gonna be higher than that 16.4?
Well,
You know what?
the number's supposed to be 16.4, but within that number, there has to be 10% of those.
10% of that
each
number has to
area.
be from each
It's about
district.
10,000.
And point of clarity, that would actually be higher because your threshold has to be far higher than your actual threshold that you need to meet.
That's
So
different.
it would be sort of more than 10% in each district to get 10% in each district, just to clarify.
Commissioner Rating?
Yeah, I was going to say that, look, even at 20%, which I'm willing to support, I will bet we never, ever see an amendment from the public. The same problem we've had for the past half century, which is why the only reason I even brought this up was to rectify that problem. I don't care, you know me, I don't care about anything performative. I don't care about changing it from the gubernatorial to the county executive and then compensating so you end up with the same number, okay? That's just basically keeping the same thing with different labels, is all it's doing. I wanted to make sure that we have a method to make it more possible, so we someday would have one of those three things that the charter says is one of the three ways that we're supposed to be able to have it, right? Have it be so we finally get a charter amendment from the public, which we've never had before. And adding these additional requirements will just completely tank it. I don't think we can get it at 20%, but I'm willing to support that as a compromise.
Commissioner Ordos.
The only thing that I just want to add a few points of clarification. I mean, the percentage that I voted yes on was the 22%, which was a reduction from my original amendment. The portion about what Commissioner Ellenboss put forth, my mind's like really around in there too. It's not something that, I didn't think that was something that we would be considering. And I'm trying to find a place because I'm not sure I'm comfortable with 20%, but I don't want this to go away either, because then we're right back at the very beginning, like all of this time spent never occurred. And so I don't know how we get back there. Without anything else, I'm not sure 20% is something that I'm comfortable with. So, but I don't know if there's any way back to the 22, so.
Thank you, Madam Chair. Just speaking to the council district requirements. I also want to point out for the commission that the council districts, underlying the basic concept that you need a certain percentage from each council district is an assumption that the number of registered voters in each council district is the same, which it is not. Districts are drawn based on population, not by registered voters. That inherently means there are differences in between each district, and further from that, over the course of 10 years, which is the time frame under which we have to operate under the same district, population growth within the districts is vastly different. Population growth in District 1 is far greater than that in District 4, and this would place a different requirements on districts of on those council districts, which is just it's very inconsistent, and I think that is an additional reason we'll be voting on.
Commissioner Mercer?
I checked that the fastest growing voting district is the 5th district and it seems to be a housing policy out there. By the way, I really like this idea, but maybe 10 years from now, it's going to be really vetted out. I'm going to support it. I'm going to support Commissioner Ellenbaugh's motion, but if it doesn't pass, I still support the motion about that. So I think this has merit. Some of us live in the county and we sort of feel honestly overwhelmed by the voters in the southern part of the county on these types of things. And so I think we're just asking for a little love, a little attention up there.
Commissioner Ellenboss?
I'm going to support a lot of what Commissioner Coltonville said. I just don't have the information to be prepared to make a vote on that tonight. It might be the best idea ever. It's very intriguing to me. Had we had more time, I might be a yes vote. So I'd have to abstain at this point, just based on not having the info that I would need to make a good decision and, consult with my constituents.
Staff, could you please call the roll?
Brad Kelly.
No.
Oh, okay, the motion that we're voting on, yes, thank you. The motion is to amend proposed amendment 19 so that at least 10% of the total signatures come from each of the 5 districts.
Brad Kelly.
Oh, yes on that.
Yes. Maya Morales.
No.
John Muchler.
Yes.
Hannah Ordos.
Pass.
Joel Pittsjordan.
No.
Andrew Redding.
No.
Jessica Rienstra.
No.
Rod Stump.
Yes.
Jennifer Wright.
No.
Doug Chadwick.
Yes.
Eamon Collins.
No.
Liz Darrow.
No.
Joe Ellenboss.
Yeah.
Lindsey Graham Ellenboss.
Abstain.
Colton Coltonfelt.
No.
Hannah Ordos.
Abstain.
Okay, and that failed with 5 in favor, 8 opposed, and 2 abstentions. So now we return to the main motion, which is to approve proposed amendment 19 as amended and send to the voters. Just to be clear, that percentage number is currently at 20.
Did you say 20 or 22?
20%. It's been a lot of things. Right now it's a 20. Okay. Commissioner Kelly, go ahead.
So a no vote on this would go back to what the charter already has been.
Right.
Correct?
So can amendment be made to,
We can do whatever we want. We've got no
to
time.
amend the 20% to 22%?
We did.
Well, and it passed the first
Why
time.
don't you try 21%?
21.3.
That'll be around number. Commissioner Ortiz. Are you proposing an amendment?
Yeah, I propose amendment, to put it back to 22%.
I'll second that.
Discussion, staff, oh, did you want to
Can-
discuss?
Can we have discussion?
Go ahead.
I think we should. I mean, I would hate to see this fail after all of this work and compromise. And I think that 22% still is a significant decrease from where we're at. So,
Point of clarification, when you say that, you're referencing this amendment, but we do have an amendment currently on the table, which is far less at 15, am I correct on this?
No, it's 20%.
No, I meant we have number, amendment 13 still.
We don't.
We don't.
We rescinded
We
that.
got rid of it. We rescinded it. That means we threw it out.
So the only thing we have that would change that section is this right here.
we're trying to keep it alive.
Go ahead, Jen.
Oh my God.
Are we able to amend, how many amendments have we made to this? Like, could I
So
amend
many.
to 21%? Could I amend her amendment to 21%?
We're at level 3 here.
I don't know if that's.
20 is as far as I'm going, just so you know.
I'm sorry, I didn't hear that end.
I said 20 is as far as I can go.
Okay, we have a motion right now to amend the number from 20% to 22. Staff, could you please call the roll?
Oh, so we can't amend it to 21?
Hold on. Oh, I'm sorry.
I don't know
I
what
need
the
to leave more
order is.
space for a second on that amendment.
Oh,
So maybe
Did you
then
second
we-
I did, yeah, and that's what we
You
discussed
seconded
it.
that one.
That was mine.
Then Commissioner Wright made one to amend it so that it's at 21%. I didn't hear a second.
I'll second that.
Okay.
I'm sorry, point of clarification, are we now at 3 levels though? I feel like
This is the 3rd level, which we're allowed. We got the main motion, we've got an amendment, we've got
I think
another
we're going
amendment.
to the 4th, no? With another amendment to an amendment to an amendment?
The amendment is the amendment to the main motion is 22%.
Right.
I mean, there's 20% currently.
That's the main
And she
motion.
has proposed an amendment to that 20% to take it to 22.
And then my 3rd level is to 21. The
I
compromise
thought
he suggested.
I thought that didn't get a second vote.
It did.
It did get a
Commissioner
second.
Stump seconded.
Oh, I'm sorry.
Staff, could you
That's
please?
4
your idea.
levels, yeah.
No,
No,
that's
because the
3
main motion has already been amended.
Okay.
Okey doke. Staff, could you please call the roll? And to be clear, we're voting on 21%.
Maya Morales.
No.
John Muchler.
Yes.
Hannah Ordos.
Are we on a simple majority or a super majority?
Simple.
Simple majority.
And then it goes back to 20 if it fails. And then we're right back where we started.
Well, you have to go through your 22. We're going 21, 22, 20.
Okay, no.
I don't think she understands it. It is, the motion, if this passes, is your original motion, but the number is 21% instead of 25. Okay? That's the statement of where we are. That's what we're voting on. And if it were to pass, then with the motion that you made as amended would be to change it to county exec and have a threshold of 21%.
Yes,
And-
but, well, you still have your motion after this motion that would change it to 22. And if both of those fail, then it goes back to 20.
Well, no, that's not true.
No, this is modifies.
Because her motion changes her motion.
Oh, so it's an amendment to the
21, So we're now
amendment.
voting on 21%.
So true. Yes, thank you. We are voting on 21%. Commissioner Ordos, I want to give you time to.
So can I get clarification on if 21 fails, then what happens?
We're back at 20. Because Commissioner Wright's amendment is an amendment to your amendment.
Fails, then it doesn't amend her
fails.
amendment. That's
All right, if it fails, then we're at 22.
Okay,
Sorry,
I
yeah, she
apologize.
said 22, then I said 21, and then it would go back to 20.
Two. It would go back to my amendment.
Okay.
Okay. Okay, sorry, no.
Okay.
Oh.
Joel Pittsjordan,
No.
Andrew Redding,
No.
Jessica Ranstra,
No.
Rod Stump,
Yes.
Jennifer Wright,
Yes.
Doug Chadwick,
Yes.
Eamon Collins,
Yes.
Liz Darrow,
No.
Joe Ellenboss,
Yes.
Lindsey Graham Ellenboss,
No.
Colton Kaltenfeld,
No.
Brad Kelly.
No.
That fails 6 to 9, and now we're back to the second level amendment. I'm sorry, this is so ridiculous. I'm sorry, excuse me. Which is to amend the number to 22% from 20%. See, no discussion.
So the main motion is at 22, right?
The main motion on the bottom level is at 20%, but the motion we're entertaining right now is to amend that to 22%.
To raise it. Thank you.
Staff, could you please call that one? Oh,
I was gonna say, only voting against it because I really would like to see 20%. That's feel pretty fair. It's right dead even from the 15 that it was and the 25% we are at now. Oh, sorry. I'm voting against the 22 because I would like to see 20. So that's just the clarification.
John Mutchler,
Yes.
Hannah Ordos,
Yes.
Joel Pittsjordan,
No.
Andrew Redding,
No.
Jessica Ranstra,
No.
Rod Stump,
Yes.
Jennifer Wright,
Pass.
Doug Chadwick,
Yes.
Eamon Collins,
No.
Liz Darrow,
no.
Joe Ellenboss,
Yes.
Lindsey Graham Ellenboss,
Yes.
Colton Kaltenfeld,
No.
Brad Kelly,
Yes.
Maya Morales,
No.
Jennifer Wright.
Yes.
And that passes 8 to 7. So now we're back to our main motion, which is so many pages ago. To approve amendment 19 as amended and send to the voters.
Which is
22%.
Now we're at 22%
22.
and connected to the executive race. Does everyone understand where we're at here?
Are we, did that pass?
That did pass.
Back to 22 now.
Yeah,
22%.
Okay.
Commissioner Ordo.
Next level was 22, and that passed.
So now we're back to this is the main and final motion, just 22, with 22% of the executive race. And if it doesn't pass,
Just nothing. We need 2/3 on this one. Yes.
Okay.
Go forward. Commissioner Wright.
Just noting that it does appear to reduce by about 3,000, the amount of signatures required, so it does significantly reduce from what it currently is, 20,000.
Okay.
Yes.
Commissioner Colton.
So I'm sorry, you're not going to vote, before you vote, will you restate?
Yes, Commissioner Colton.
Yeah, thank you. Just for clarity's sake and transparency for everybody, if this vote fails, it would, go back to what it was before. I cannot stomach setting it back to where we were when we were here trying to find a compromise, so I would make a motion to rescind my motion to reconsider my recension, because I feel like it's comparable to setting it back to where we were before, just to be fully transparent. So I would encourage us to come together here and try to find some sort of agreement.
That's a pretty good bargain too.
Well, it's better than where it was before. I mean, that's crazy to set it all the way back and waste all this time. And that's not why I voted for rescind, you know. If I had known that that's the alternative.
Point of clarification, are you saying that you would rescind your vote to?
I would make a motion to reconsider my recension of the original amendment that we passed way back in the day. No, I'm not. It fails. I see. Yeah.
I guess if it fails, you're saying if this fails.
If we fail this vote, and it would have defaulted back to where it was at the very start of this commission's work.
Okay.
Yeah, because I came here to, you know, find a good faith compromise, and that's 100% in the other direction.
22 is in the other direction.
No, well,
I'm sorry.
I would personally like to see it at 20, because that is the dead middle of where it was and of where it was before and where we are here. This whole commission, you know, we've been building up, trying to find it in the middle. So I personally would like to see it at 20, honestly. I'm a little disappointed that it moved back up to 22. But yeah, if it's only if this main motion fails, and it would have gone back to the 25% of the gubernatorial.
So
Yeah, no, I'm not making that
Are you
motion
in
yet.
support of where we are right now? Are you in support of this vote? Yes, so that something passes. That's my
I
question.
guess,
Okay.
yeah, I
Okay.
guess.
Thank you.
Very begrudging.
Thank you.
Commissioner Redding.
Yeah, so I'm not going to support this. I was willing to go to 20, that halfway point. I'm not gonna lend my name to something that's purely performative and that guarantees that we will never have an amendment from the public. I'm never willing to be performative, and I will call this out. I stand for being able to have the public have a realistic way to go directly onto the ballot. And this does not provide it at 22%. I don't think it does at 20%, but I was willing to compromise at the halfway point, but I'm not willing to go this far.
Commissioner Morales.
Yeah, I'd like to motion that we amend this motion to 19%.
I'll second that.
I feel like, and I'll just justify that, thank you for a second, Commissioner, and I'll justify that by saying that it seems, I'm feeling in the room some frustration with really wanting to send something significant to voters and not something that puts us like deadline on the same number, and something that eases the public's ability to bring forward a charter amendment, no matter what that amendment may be. And I will, you know, I will note that I am not attempting to ascribe intent. I don't know what those amendments might be, right? I'm not trying to predict what the public wants to do. But I do think that is incumbent upon us to provide a remedy where there's a right. We have a right in our charter of the people to bring an amendment, and it's never been done. And having been on a ballot initiative committee myself and knowing how hard signature gathering is, I think that Commissioner Rienstra made a really important point when she pointed out that it's really an undue burden to only prescribe a high number, thinking about paid signature gatherers and wealthy individuals making a charter amendment, instead of thinking about the positionality of people. And it doesn't really make sense to put up that barrier without thinking about the experience of people, whether that was a wetlands or flooding issue, whether that, you know, no matter what the issue is, if it's a people's remedy, it's got to be able to be attainable by the people, and we know that it's not. And so that's the reason I'm bringing this motion. I'm not trying to anger anybody. I really just, I want us to attend to the people's will. And I also do feel that that's part of why I want to serve on this commission, is because I want to represent people and I want to make it easier for people to be represented in government, including their decisions. And so, sorry for that wording and stuff.
Motion, second, go ahead, Commissioner Stump.
I just wanted to touch back on the recension, Colton. I really, you're passionate about it, I appreciate that, but I don't think you voted to rescind on anything other than you did what was right, because this would have been a non-discussion if it would have had clarity out in the Deming Library. We wouldn't be talking about this past amendment, right? I think you both did with the right thing, and you knew that we were all confused. We had a lot of confusion. There was arguments after that. I know I'm gonna get corrected here, but I appreciate you doing the right thing. I appreciate your honesty and your integrity. So thank you.
Madam Chair.
Yes.
I would advise to oppose this particular amendment, asking the body to consider that whether the 22%, actually even the 25%, is roughly 2/3 of what is required to change our state constitution, our federal constitution, other charters. Our threshold is way below that already. And so in order to be fair, just because we had a number that some could argue might be too low, in order to say that lowering a little bit more than that is not enough. A constitution or a charter is supposed to be difficult to change. And we're making it, the proposal at 22% makes it simpler.
Commissioner Mushler?
I think there's a case to be made for clarifying language, so the language is consistent throughout the charter. And I'm going to share something that maybe folks don't know. We have referenced the gubernatorial election as our standard, and we've referenced the executive council race as a standard. There's a third one that's was in our charter until 10 years ago. It was regarding the initiative and recommender process, where we went from 15 to 8, but it says in the past it was 15% of the number of votes cast in the last general election. It was a totally different category, but we got rid of that. We got it down to 2 instead of 3. So I think there's a good case to the citizens. Even when we have, some people think we're going to move the dial very much. I think we have from 25 to 22. I think it's healthy that when people read the charter, they see consistency and uniformity.
Commissioner Bistro? Commissioner Redding?
Yes, percentages are actually meaningless. It's the number of signatures that you need to get that is the thing that actually determines whether it's possible. And so, you know, the critical thing here is to look at the most signatures ever submitted. That's 13,000, as I've said. At 20%, it would be, I don't know, it would be something well over, will be over 20,000.
No,
That you have to
16.
get. Yes, in terms of in terms of the number you have to collect in order to get valid signatures confirmed by the auditor, that's what I'm talking about. So that's a ton of extra signatures you have to collect because so many are invalid. So I'm just saying that we've never come anywhere close to that in our whole history. And that's why we've never had a charter amendment from the public. And the only way we're going to ever get one is to bring it down into the range where, you know, the maximums that we've had. That's my problem with this, and that's why I'm not willing to be performative.
Commissioner Wright?
I will motion to, wait.
We have a motion on the floor.
Oh, we have a motion.
Can I like amend?
Yes.
Yes.
And just a point of clarity, the reason I said 19 is because we haven't considered 19 before. I think considering the same number over and over again is not really kosher, so I
appreciate that.
I do agree that just considering the same number over and over again isn't necessarily productive unless this conversation has resulted in a different outcome, perhaps. And so I am going to propose a secondary amendment to that from 19 to 21%.
think we have considered 21.
Second.
Right, we have, but I am looking at it differently now.
We have a motion and a second. Any discussion?
Chair, order, I don't think we can read, I mean, we already.
We have already.
We
already
did
have.
22 twice.
Yeah.
I have 21 on here that we voted on an amendment to change it to
Right.
21, no, we've already voted no on.
Right, we voted
Right,
on
we
22
voted on
twice, though.
22
We
twice.
can revisit it.
I was in the middle of trying to make a motion though, I got it.
Sorry.
So I don't know.
Okay, I thought you were taking it back. You're trying to make.
No, I was.
Okay.
I got interrupted. And so if we're gonna do it again, can we do 20? One motion.
Your
Just to
motion is-
amend
okay.
the
Amend it
19 to 20.
Okay.
Well, Lindsay.
Because I've heard that can be, people are willing to vote yes.
I'll second that.
Okay. Step.
And second vote, right?
Well, I was in the middle of,
It's an amendment on, no.
she had started and then I got,
No, I made.
We haven't made him all
like.
amendment. We have Morales.
And
I,
Lindsay.
I thought you paused it once, so I didn't know.
Sorry.
Yeah,
I didn't realize.
I'm sorry.
we were
When she
still-
pointed at me, I thought you had told her to go on, so I'm
oh,
sorry.
sorry, no, do
It
you?
wasn't me.
I can,
Apologize.
okay, is it okay? I'll amend to 220.
Okay, so.
Can we skip that and then, and I'll change my amendment to 20?
Okay.
Okay.
That sounds good.
Then we
So for the
can.
I want to see
public,
it pass.
what's happening is.
How about just for ourselves?
Right now.
And I also have requested we go to a break after this, so we can use the restroom.
For sure. Okay, so Commissioner Ellenboss has offered an amendment to Commissioner Morales's amendment that would change the percentage number to 20%.
Can I second that? Or did we have a second?
We had a second already.
Okay.
I'll second. Step 20%. Steph, can you please call the roll? Oh. Go ahead.
In deference to my colleagues, too, I would be voting in favor of
And what is?
The motion is to amend the original motion so that the percentage that we're talking about now is 20%. As an amendment to Commissioner Morales's amendment to change it to 19%. Does that make sense?
And a yes vote would go to 20 instead of 22.
Change the original motion to 20.
But a no vote, if it doesn't pass, we send it 22.
Yeah.
Then we'd have to vote on 19.
Well,
There is an amendment, a secondary amendment to change it to 19, but
well, no.
this amendment is amended.
I don't know if 19 or 22 is gonna pass. 20 was
Commissioner Muchler.
We're at 20, right?
Yes.
This vote right now we're about to take is to change it to 20.
I'd like to see the main motion pass. Take some compromise, that's what I'm supporting.
Steph, will you please call the roll?
Joel Fitzjordan,
Aye.
Andrew Redding,
Yes.
Jessica Ranstra,
Yes.
Rod Stump,
Yes.
Jennifer Wright. Yes. Doug Chadwick,
Yes.
Eamon Collins,
Yes.
Liz Darrow,
Yes.
Joe Ellenboss,
No,
Lindsey Graham Ellenboss,
Yes.
Colton Coltonfelt,
Yes.
Brad Kelly,
No.
Maya Morales,
Yes.
John Mushler,
Yes.
Hannah Ordos.
Yes.
Passes 13-2. We are back to the main motion. Just to
Call the question.
approve amendment 19 as amended and send it to the voters. And to be clear, this would change the percentage of signatures required to 20% and link it to the executive race.
and the numerical amount would be.
Well, for the last election, that was roughly 16,409, but who knows next time how many people.
As compared to what it is currently.
20,862.
How much?
20,862.
So a reduction of how many?
4,441. Commissioner Wright?
But I will point out that it is, as Commissioner Coltonfelt mentioned, it's halfway in between, and that he and we voted to rescind 13, so we could have this discussion and come to a better compromise. So I would ask people to please vote yes on this.
Staff, can you please call the roll?
Andrew Redding,
Yes.
Jessica Ranstra,
Yes.
Rod Stump,
Yes.
Jennifer Wright.
Yes.
Doug Chadwick,
Yes.
Eamon Collins,
Yes.
Liz Darrow,
Yes.
Joe Ellenboss,
No.
Lindsey Graham Ellenboss,
Yes.
Colton Coltonfeld,
Yes.
Brad Kelly,
No.
Maya Morales,
Yes.
John Mushler.
Yes.
Hannah Ordos,
Yes.
Joel Fitzgerald.
Aye.
That passes 13-2. We're now gonna go to a break. We'll be back at 8:40. Call this meeting back to order at 8:40 p.m.
Yeah.
Just so that the public knows, we've got 8 amendments to go. This is the last meeting, this time that we can vote on these proposed amendments so that the auditor has time to prepare them for the election. So should we go another 2 hours, I'm going to propose another break. But it is my intention, and I believe the will of the body, to get through the rest of these amendments that we have here before us tonight. So thank you for being here on this adventure with us. Next up is proposed amendment 24 from Commissioner Mutchler on requiring a 2/3 council vote to use banked capacity. Do we have any public comment on amendment 24? Sandy Brewer.
In the interest of moving along, I will yield my time.
Thank you, Sandy. Is there anyone else signed up to speak? Commissioner Mutchler, would you like to speak to your amendment?
You know, I think my greatest fear is taking up your valuable time. By the way, thank you for even looking at this again. I'm humbled and appreciate that. But my fear is that our minds can be made up sometimes. And this is the one amendment I personally feel the strongest about. The principle of the supermajority is baked into our charter. It's actually baked into our country. It's baked into our lives. Later today, we're going to look at changing the requirement from 10 votes to a majority of the Charter Commission. I want to remind you, it was not a radical right-wing or radical left-wing council that brought that requirement for a supermajority for the commission. It was these people: Red Brown, Carl Weimer, Ken Mann, Barry Buchanan, Barb Brenner, Keith Kremen, and Seth Austin, who were the council members there. And I think it was unanimous to bring that to us, and the voters approved it. We didn't have any say in the matter when we were on the commission. Voters, raising property taxes is a serious matter. It's a super reliable source of income, because if somebody loses their house and goes bankrupt, the first person in line to get their money is going to be the county and the state. So it's a pretty serious matter to raise property taxes, which is what we had initiated 747. And even today, it takes 60% of the voters to pass a property bond levy. I mean, if you're going to raise property taxes for a jail or for a school or for a city hall or for a library, it takes a supermajority, in a sense, of the voters, 60%. We've also talked tonight, one of the earlier amendment, I forget the number now, on affordable housing. And part of affordable housing are taxes that go into paying the property tax on those houses. And I was curious, and this is maybe my main point, and inviting each of you to do a little homework yourselves, is I wanted to know if property taxes have stayed pace with inflation. And you can look this up. The U.S. Bureau of Labor and Statistics has calculated inflation rates over the years. And I had to decide, how far back do I go? I went back as far as the county website, the assessor's website lists our property taxes. It goes back to 2006. That's the earliest online you can find out what your property taxes were on your house. So I thought, what's the inflation between 2006 and January of 2025? Let's say 18 years, something like that. It's 60.2%. So try to remember that number, 60.2%. So just out of curiosity, I looked up some of your homes. I'm not going to tell people where you live, but I thought, well, how do I figure this out? I started with my home, and my first home, and let's see, find that here. 73%. So that period of time, by the way, that 60% might seem kind of low. We had those years of 2 and 3% inflation. It wasn't all that bad. It's going to be worse now. But my home, instead of 60%, over those 18 years, 73%. I looked up the mayor of Linden. His is up 133%. Somebody in this room lives on G Street. That home on G Street has gone up the property taxes has gone up 244%. Another one of our commissioners lives on Eldridge, or at least owns a home on Eldridge, 274%. Somebody lives on Cedar Drive out in the county, and 125%. Someone's on the Noon Road. You know who you are. 110% increase in the aggregate property taxes. I looked up our county executive, 169%. And one of our council members, whose first name begins with Todd, his property taxes went up 126%. Couldn't find the rest of you. But inflation is 60% and all of our property taxes have gone up. There are a few exceptions, but they didn't. I looked up a multifamily in Ferndale. It went up exactly the same way as inflation. The last thing.
Sounds like we're paying our fair share.
I think we are. The last thing I want to share is this county council inspired me to do this. Last year, they had to figure out how to pay for government. And so they decided to take 100% of the bank capacity in the county road fund. That was $3.9 million. If you excuse me, I'll just say $4 million. And that's not just 1 year, that's baked into the cake. And so every year it's an additional $4 million. That bank capacity does not exist anymore. In 10 years, that's $40 million. Now, what could they have done? They passed that increase on a partisan vote, 4-3. They were right to do that. I would like to see something we have to work a little bit harder. They had options. They could have taken half the bank capacity, $2 million. They could have taken a quarter of it. They could have, if they had been required 5 votes, they would have to negotiate with the other side. You know, maybe we can cut here, maybe we can add here and do something different. But they took the entire amount. I just think that's just not right. And I think this is a simple, common sense approach. It's such a county council. Sure, you can take bank capacity, and they still have $2.5 million in the general fund they could take. And somebody cynical might say, well, if we pass this, they're gonna take it right now while they can. I don't think they're that kind of people ought to do that. So I make a motion that we pass the proposed charter amendment 24, which would require a 2/3 council vote to increase property tax levies using the bank capacity.
Second.
Commissioner Jordan?
Thank you, Madam Chair. I will be asking for a no vote on this particular amendment. I certainly appreciate the grave policy problem that is increasing property taxes. What I want to point out is that the increase overall over time of property taxes, when we're talking about the aggregate, not just isolated cases, says more about the trend of the economy than it does the actual governmental decision-making. When the value of your home or the value of a particular sector goes up in relation to the other sectors or the homes around you, your property taxes increase. And in Whatcom County, over the last decade, we've seen single-family homes and multifamily homes both almost double in value in terms of their market share, whereas commercial property has only marginally increased, industrial property has actually decreased, and other property is increased at a somewhat marginal rate. What I would be more comfortable with the concept of inflation plus population growth, effectively saying that expansion of services on a per capita basis would require a level of greater scrutiny. I'd be even more comfortable with the concept of effectively saying that if we are dipping more into the county's overall wage and salary bucket, that that would require a level of greater scrutiny. But I do not believe that 1% is the threshold to use. It is not a number that is the underlying number that came from that initiative is not based in any kind of financial best practice. I strongly believe that, once again, I do not believe that 1% is the threshold, but would be more comfortable with a greater threshold.
Commissioner Redding?
Yeah. I have a problem with the terminology because democracy is simply the side with the most votes wins, just that simple. And so that does mean majority, but when you say supermajority, it makes it sound like if it's more than a majority, then it's somehow more democratic. But if you think about it, if you took that would mean that the higher you make the supermajority requirement, the more democratic would it be. Now you take it all the way to 100%, and you'll see that in that place, democracy disappears altogether, okay, at that point. And so actually, as I've pointed out in a past meeting, it's minority veto is what it is. And you may like that, but the point is that's what it is, and it's not democracy. And so that's why I oppose every instance of supermajority, whether it's for school bonds, whether it's for, which 60% I think that is. And that means that people who no longer have kids are given a veto over people who do have kids and their education. I think it's very anti-democratic overall. And so I'm going to be opposing this.
Commissioner Alba.
I knew the previous question.
Sorry, I couldn't quite understand what
I
you said. You want
moved
to
the
call the
previous
question?
question, which ceases debate.
Okay. We're gonna
Non-debatable.
need 2/3 to do that, yes? And you had a second, Mr. Morales?
Oh, I was just gonna say, I was
second
gonna
it.
ask you to
Okay.
limit debate if possible, so.
Okay, staff, could you please call the roll? We are voting right now on calling the question, meaning we're ending debate.
Jessica Rienstra,
Yes. Oh, I'm sorry, excuse me.
no,
Wait,
I'm sorry, just to end debate.
We're voting to end debate, correct?
yes. Yeah. Commissioner Rienstra, I just want to make sure we got your vote.
Yes, I apologize. Yes.
Rod Stump,
Yes.
Jennifer Wright,
Yes.
Doug Chadwick,
Yes.
Eamon Collins. We couldn't hear you, Eamon.
Yes, yes.
Liz Darrow,
Yes.
Joe Ellenboss,
Yes.
Lindsey Graham Ellenboss,
Yes.
Colton Kaltenfeld,
Yes.
Brad Kelly.
Yeah.
Maya Morales.
Yep.
John Muchler. Hannah Ordos,
Yes.
Joel Fitzjordan,
Aye.
Andrew Redding.
Yes.
Okay, and that passes 15-0. Staff, could you please call the roll? Now we're voting to pass proposed charter amendment 24 to send to the voters. This will need a 2/3 vote.
Rod Stump,
Yes.
Jennifer Wright,
No.
Doug Chadwick,
Yes.
Eamon Collins.
No.
Liz Darrow,
No.
Joe Ellenboss,
Sure.
Lindsey Graham Ellenboss.
Yes.
Colton Kaltenfeld,
No.
Brad Kelly,
Yes.
Maya Morales,
No.
John Muchler,
Yes.
Hannah Ordos,
Yes.
Joel Fitzjordan,
No.
Andrew Redding,
No.
Jessica Rienstra.
No.
And that fails 7 in favor, 8 opposed. Moving on. Next is proposed amendment 28 from Commissioner Redding on changing the vote threshold for approval of amendments by the Charter Review Commission from a supermajority to a majority. Are there any public comments on amendment 28?
No.
Commissioner Redding, would you like to speak to your amendment?
Sure, and I'm going to keep this as short as possible in light of the late hour. And I've essentially given the argument for that in large part in the last comment I made. I'm just not in favor of these kinds of minority vetoes, so that's why I'm proposing it. I don't expect it to pass, but I do want to vote on this and do want to have an opportunity to vote yes.
Can I hear a motion?
So motion to adopt, yes.
Second.
This is Madam Chair, would you say, sensing you're ready to vote, if you get no objection, we go right into a vote where you don't have to do that. Call the previous question.
I hear that. Seeing no discussion, looks like we're ready for a vote. Staff, will you please call the roll?
Jennifer Wright,
Pass.
Doug Chadwick,
No.
Eamon Collins. Can you repeat that, Eamon?
Yeah, sorry, yes.
Yes. Liz Darrow,
Yes.
Joe Ellenboss,
Yes.
Lindsey Graham Ellenboss,
No.
Colton Kaltenfeld,
Yes.
Brad Kelly,
No.
Maya Morales,
Yes.
John Muchler,
No.
Hannah Ordos,
No.
Joel Pitts Jordan,
Yes.
Andrew Redding,
Yes.
Jessica Ranstra,
Yes.
Rod Stump,
No.
Jennifer Wright.
Yes.
And that amendment fails to go to the voters in a 9-6 vote. 9-6. Next up is proposed amendment 29 from
Madam
Commissioner.
Chair, what was the result? of that
Oh,
vote?
it was 9 in favor and 6 opposed.
Okay, thank you.
You're welcome. Proposed amendment 29 from Commissioner Ellen Boss on requirements of the prosecuting attorney and counsel regarding initiatives. Are there any public comments on amendment 29?
Yes, I see Cleveland Harris online. Cleveland, go ahead.
Excellent. Thank you. I would be worried about this one. Just worried about like, you know, I know it's like a non-binding thing, but I was worried that it could persuade or dissuade voters. And yeah, I guess that's my main concern about something like this, is having the prosecuting attorney kind of give an opinion on something, whether it's in lawful scope. I think what's in lawful scope to me sometimes is to the person who's interpreting it. I think a lot of laws go up all the way up to the Supreme Court because of that reason. And so I just think something like this would be putting, yeah, undue burdens on voters getting something to the ballot. So thanks.
Her name is Cleveland Harris. Are there any other public comments?
No.
Okay, Commissioner Ellen Boss, would you like to speak to your amendment?
Yeah, I will also keep it short since it's 9 o'clock. There has been, well, it's pretty long, so you all have a copy in front of you. This is in response to a lot of what we talked about earlier when we were debating the numbers about how difficult something should be for people to have an amendment or initiative or produce an amendment. And this is intended to support the people that do that work to gather those signatures and put something to the point where it is ready to go on the ballot so that there aren't unnecessary obstacles from within our government structure. So there has been some response from Helen a couple times from myself and other commissioners about 5.61 and 8.25. They do not believe that's something that they would be able to do, and I am okay with striking those from this document. So that would be leaving 5.62 and 8.2, 8.26.
Sorry, striking 5.61.
5.61 and 8.25. So I would like to move to adapt. Second.
Commissioner Redding?
Yeah, I certainly sympathize from the standpoint as someone who's collected signatures. There's nothing more frustrating going through that whole thing, getting them certified, and then having it all go down the drain. On the other hand, I have a different concern as well, and that is that it really hurts our process if something does get on the ballot. You go through this whole election campaign, it passes, and then it turns out that it's ruled unconstitutional. And so I would rather have some kind of a ruling that happens before then, ideally even before the signature gathering starts, so you don't go through all that work for nothing. But I don't like anything that causes more cynicism about the system. That's my big concern with this.
Is there a version of this that would, something that could be removed or changed or?
I'm afraid, I don't know. I'm feeling like if there was anything we could do, it would be to have a more effective process of vetting at the point where this is submitted, right, to the auditor, I guess it is, or to, it goes through some kind of, it should be going through a thorough vetting process before it goes out for signatures, so that you don't have to go through this incredible frustration. I can't imagine the pain from what happened with gathering all these signatures and for nothing, right? It's horrible. The ideal would be to have that be some kind of better process right at the beginning.
Something other than a legal review,
Pardon me?
other than a legal review?
Before it goes, I'm saying before it goes out for signatures is the ideal place. Because you don't want to be gathering signatures for something that's not going to hold up to legal muster. It's a terrible waste of effort. And I don't know how to do that. That's not described in here, but it's something to think about.
Well, that was number 5.61 before we were told it might not be allowed. Advice.
I see, yeah.
Advisory opinion.
Commissioner Morales.
Yeah, it's my understanding that, when you file the original language for your amendment, that it does get a pass-through and it gets titled. And so I'm wondering if our council has any insight on that. I'm not sure, if you don't, it's cool, but I think.
He knows, he's done lots of research on it.
Okay.
There's a general review by the auditor's office, just as to form, to make sure it meets the form requirements of whatever the proposal is. The auditor's office nor the prosecutor's office does any kind of legal review as far as the legality of whatever the proposal is. There's a case out there where some cities had attempted to have kind of a gatekeeper function in the city attorney's office, where a city attorney was actually preventing things from going on the ballot, that sort of review. That was found to be improper. That's why this was originally proposed as a non-binding advisory opinion. I feel that under the home rule constitutional provisions, the charter can't change the powers and duties of the prosecuting attorney's office. And the way it was proposed originally, I saw as creating a new duty on the prosecutor, which I think is outside the scope of home rule. And that was why my advice was that it not be included.
Go ahead, Commissioner Mushnick.
Yeah, could Commissioner Elmbaugh, repeat, you're submitting the entire page 25 and 26, where you remove what?
The advisory legal review sections, 5.61 and
You excluded it from the list,
8.25.
Right. So it is to adopt amendment 29 as amended. We could say as revised.
right? Okay.
Commissioner Mushnick, go ahead.
So we wish we had had this a year ago, right?
Some people do.
Yeah. And is that the only event that's occurred where we have this problem?
I'm not aware of previous similar situations,
Yeah.
but
That's my struggle with
Yeah.
it, is to add this to the charter.
I do expect that we'll be seeing more
You think so?
of these, and so we should be prepared to support those efforts.
Fair enough.
I have one more legal question.
Go ahead, Commissioner Morales.
Mr. Chair. I'm wondering if you could clarify for us, our council, if there is rulemaking within the auditor's office that would allow a little more in-depth legal review at all, or if that's just totally precluded.
Generally not, simply because the prosecutor's office doesn't represent the proponents of an initiative and can't really give them legal advice and create that kind of relationship with them.
However, if a citizen approaches the elections department, the county auditor, with a challenge or request for information as to whether or not there are perceived problems with it, the auditor would approach, the elections department would approach their assigned counsel to give an opinion on that already, right?
Potentially, I think it might depend on the type of challenge that's being presented, whether it's a sort of a form challenge rather than, you know, the situation we've all been talking about. It was a substantive challenge to the actual nature of the proposal. I think that would be outside the auditor's purview.
I do think it would be important, it hasn't come up many times like we just discussed, but when it does come up, giving clear guidance within this charter document to the council is probably one of the primary goals of this. So if that could look like maybe I know we don't like a supermajority, some of us here, a supermajority vote before taking action, that would be something I'd be open to amending. I'm very open to molding this into something that fits the goal. Liz.
Oh, sorry. Go ahead, Commissioner Martinez.
I'm also wondering, First Amendment issues on that very opening proposal. Is this saying that if a county council member is against something, he can't speak against it from the dais, or whatever you want to call it, or from any venue? It seems like, interfering. You know what I'm saying? It's like,
Well,
doesn't the council member have a right to speak?
they can use their personal resources, they can't use county resources. And they can never speak about their position on initiative from the council.
So, for example, our city council sometimes, we resolve to support the school levy, you know. I know it's not quite the same thing, but they'll pass a resolution of support for something going on in the community. Are we saying by this, a county council that might feel strongly about something can't pass a resolution, we resolve that we are against initiative A, B, or C, or this? Yeah, do that.
Can they do that now?
Yeah.
Yes. This was in the cover.
There's a rule on expenditure of public funds for election purposes. It's been interpreted different ways, I will say. I don't know if there's a
Might
clear
we just
answer.
solve that question by inserting the county council should take no official action to impede or whatever. If the county council, it's not individual council members, but it's county council of the body, should take no official action to impede, alter, or prevent the measure from being placed on the ballot. Does that answer your question or your concern?
So are you concerned that by doing that would be an interference on county resources, or, because I don't see that conflicting with the.
I know the legislative bodies like city councils and county councils, sometimes, you know, we feel very strongly about this, and so we're gonna craft a resolution stating our support or non-support of X, Y, or Z, and all it is a vote. And it may be majority, it might be 6 or 7. That's a free speech issue to me.
I don't see number 2 restricting that, and it'd be restricted in a different way.
So if they were against this initiative.
But it just says you can't use public funds, county resources, or initiate litigation.
I won't look at the opening paragraph.
I wanted to speak to that. I don't think it's a First Amendment issue because I think you've clarified that in a personal capacity, council members can speak however they want. I actually see it as a powers issue because essentially it binds the hands of our council from taking any position whatsoever or even really discussing it. And I think that the reason I think that could be a little difficult for the council is because they will need to do certain procedural things regarding initiatives. And I think it could be a little bit tricky for them. I speak as someone who has brought forward an initiative that a council did pass a unanimous resolution against. Okay, so like context here, I've been on the not very fun end of this before. At the same time, I did think that it was their legislative power to be able to do that.
So do you have a suggested amendment?
So yeah, I mean, I guess what I would say is that I don't think this violates First Amendment necessarily, although it might run amok with those issues in other capacities where if a council member is speaking at an event and they're sort of known as a council member, but they were voicing their own opinions and clarify, it could get a little tricky. So I would say, I think that this might dig us into some difficult to weed out areas, the way it's written. I'm not sure I have an amendment, but someone else can think of something, might be open to that.
Commissioner Ordos? Oh, I'm sorry, I thought you had your hand up. Okay, Commissioner Redding.
Yeah, I want to echo something that Commissioner Munchler said. I do feel like since this has happened only once that we know of, that it feels a little bit like litigating the past. It's not like there's been a series of these things. And I do want to point out that when it did go to court, there was a court decision finding it to be unconstitutional. And I realize there's an appeal process, but I also realize there's been no reversal, at least not so far. And so if it had come out otherwise, if it had been taken to the court on the public dime the way it was, and the court had said, are you kidding me? Then there'd be a much stronger case here. But given that, I just think we're being a bit premature.
Commissioner Elbaz?
Yeah, time saver. I feel like I'm needing to move the previous question unless the chair handles it her way.
Yeah, it does seem like the body is ready to vote, although is that your hand, Commissioner Elbaz? I did just want to say, I'm going to pass the gavel briefly and just say that I think it's an excellent point being made that a council can influence the outcome of elections by these resolutions. And I personally feel like that's really unfair and has been wielded against the voters a number of times in 7-0 votes. I see it more with city council. I can't think of an example. I'm sure there are some with county council, but I think it's really bad faith for a council to do that to voters because people who don't have time to look into these issues, they trust the people that they elect to represent them. And so I do think the outcomes of elections are swayed in that way. And so for that reason, I really appreciate Commissioner Ellenboss doing this work and striking these two sections to me that I don't see a reason not to support it. So thank you for doing that work and being flexible on it. Commissioner Muchler, go ahead.
I totally find to support it. I just want to take a moment to ask our attorney, the opening paragraph, does that create a First Amendment risk? If the county council comes out and says we are against this initiative and we vote as a resolution against it, I think it'd be conflict with this or First Amendment.
Seems like Commissioner Ordos has a hat on.
I'll just say while he's looking that up is that the county council is told at the beginning of every county council meeting that they're not to discuss any campaigning or initiatives that are on the ballot or any of those types of things. That's one of the first things that the chair says in the beginning of each council meeting. And so, and this is referring to the council as a body too, not just individuals on their own time that want to support something.
I'll just say, I believe with the provision that protects their private right to speak out about any of these things, I think it would be okay with the First Amendment.
As is.
Commissioner Redding?
Yeah, I just wanted to point out that in the case of city council doing that, and I was very critical of that, it doesn't mean that they had any success. The public really slapped it in their face in the votes. In fact, 3 of the 4 eventually made it and passed by substantial margins against the unanimous opposition of council members. Pardon me?
I was thinking of another initiative. I was thinking about Proposition 4.
Okay.
And okay, so seeing no further discussion, staff, would you please call the roll? Oh, I'm sorry.
I was just gonna suggest an amendment.
Oh, okay.
I think in paragraph 1, where it says section 5.62, it says the county council shall take no action to impede, alter, or prevent the measure from being placed on the ballot, nor shall they engage in actions intended to influence. I'm wondering if maybe it would make sense to strike out the last part of that sentence.
Starting where?
The nor shall they engage in actions intended to influence the outcome of the election, because I feel like that's sort of implicit in the rest of it. And that first clause is very clear that they will not impede it from being placed on the ballot. And it doesn't run amok of any First Amendment issues that way in any context, whether from the dais or elsewhere, like a community event or a speaking engagement or whatever.
I'll second that for conversation.
So it would be from nor to the end, so it'd be nor shall the council, but that phrase would be struck, that's my amendment, if it's done or not.
Oh, actually, I would accept that as a friendly.
Yeah, thank you, Madam Chair. I just looking at subsection 2 and 5.62 on not expending public funds. My understanding is that public funds refers not only to county funds, but also state and city funds as well. So if we have a county council member who is also an employee of the state, this would prevent them from utilizing their, like if they're in a public position.
That's
in a
not my
professional
intent,
capacity.
so is that how you read that?
I'm trying to think of what you're envisioning as far as a council member having access.
Like the county council member is in a, they're a part-time role. If they're in their professional capacity, a state employee that somehow ends up overlapping with an initiative at the county level. I guess my question would be, would it be sufficient to remove public funds? Using county resources, I think, is sufficient to the intent that you're trying to get at without the.
Yeah.
Yeah, okay, I would motion to remove, expend public funds. The sentence would just read, the county council, its individual members in any county department or office shall not use county resources.
Before we second that, what if we just substituted public for county?
Sure.
Because then you're still spending the our Whatcom County money on it.
Sure. Yeah.
Does that seem better to you? I
Is
just
that
have one of those.
Yeah, that works.
Okay. You don't like this, okay.
So what would it be?
It would just say you can't expend county funds.
Point of order, Madam Chair.
Yes.
This individual is confused. We were discussing a motion to strike the latter language in the first paragraph, and we're now talking about language in the second paragraph. Are these two different amendments?
Yeah, Joe, the
Right,
first was a
coming
friendly
to-
amendment, which I accepted, and then another friendly amendment was offered.
Oh, okay. That's dangerous.
Friendly.
It's my understanding we need to, are you saying that we need to vote on these two things separately? Is that the clarification you're making, Commissioner Elba?
Well, it depends on whether they're amendments or, I mean, what's before us is this. And for two individuals to agree is not the entire body to agree. So if there's language about modifying it, it technically needs to come before the whole group.
Okay, well, let's take these one at a time really quickly. What?
This is another amendment / question. Is that, am I in order to ask that?
We've got the original and then we've got these two extras, so we need to get through these. I think it'll be really quick because we have
No, this is just about the text, and I think I should probably voice it now.
Okay.
Later.
Go ahead.
Which is just so on that sort of First Amendment issue that we were talking about and taking language for, so it says, in section 2 there, that the county council, its individual members and the county department, and then in 3, it says nothing in section shall prevent individual council members. So I think I'm wondering, is that phrase in number 2, it's individual members, inconsistent with 3? Should we just strike individual members?
No, the difference is me here acting and me at home when I recognize myself as Lindsay Graham Ellenboss, private citizen of Whatcom County, as opposed to in my elected capacity as a charter commissioner. So that's why it's important to differentiate, because we want to protect your ability on your own.
Yeah, I get that. What I'm raising a slightly more intricate issue, which is that number 2 prevents lawsuit by, but number 3 doesn't provide for lawsuit by in the private capacity. So I'm just wondering if we include its individual members in number 2, if a council member wanted to bring a lawsuit in their private capacity, it seems like they could not. Am I correct?
Yes, I would read this as prohibiting a council member from initiating any litigation on their own.
Is that a little problematic?
I don't know the answer to that.
It feels, my opinion would be, it would be slightly problematic.
What part does that? I'm sorry, what word specifically make this problem?
So the inclusion of its individual members in number 2. It says that they cannot initiate litigation to advocate for or against. And then in number 3, it just clarifies like personal opinion. So essentially that could prevent a council member in their individual capacity from bringing a suit. Does that make sense?
Yeah, so we just said individual members in their elected capacity. Does that solve the problem?
That would be better.
Okay, and then
That is, yeah.
can we do all these friendly amendments and if nobody like, has a big, can we like approve the friendly amendments together? Or do we have to do
We
each
don't need to
individual?
do them by roll call.
Okay.
That's my understanding, but we do need to do them by vote.
Well, you could do that, Madam Chair, you could do that by consent, but you need to deal with each one before you
Yes.
go on to the next
Okay.
one. And I'm a little rummy,
I heard
I'm
you.
waiting behind.
Okay, well, let's start with the first,
sorry, I just
which
don't
is,
know.
the amendment proposal that we're dealing with in front of us right now is to strike the language from section 5.62, number 1, where it says, nor shall the council engage in actions intended to influence the outcome of the election. We have a motion and a second. Are there any opposed to doing this by consent?
Can you clarify this?
Oh, boy.
Was it me?
Asking me to go back.
Yeah.
Yes,
You did that.
Yep, for discussion. Yep.
Commissioner Ellenboss, yes. Is there any objection to doing this by consent? All those in favor, please indicate by saying aye.
Aye.
Okay, next amendment.
Wait a second, that wasn't the vote on the amendment. was it?
Just accepting the amendments.
Amendments to the language.
Just accepting.
Oh, okay.
Okay, we have
Everybody's getting sleepy.
an amendment proposal to this amendment language to strike, or to, to change item number 2 to say, the county council, its individual members, and any county department or office shall not expend county funds, use county resources, et cetera, et cetera. So I'm changing that word public to the word county, spend county funds. And that was moved by Commissioner Wright on the side.
I think he
started?
motion it.
So
It
we
was
read it as-
his baby. Let's let him have it. I just suggested
Okay.
a different word.
Who's the second on that?
I could be the second.
Okay, great. Yes, Commissioner Mutchler, I can read it as it would be. The county council, its individual members, and any county department or office shall not expend county funds, use county resources, or initiate litigation to advocate for or against, or to legally challenge the validity of, et cetera, et cetera. And then we had a third amendment proposal.
We have to do them individually?
Yeah.
Let's do that one first.
Okay, is there any objection to deciding this by consent? All those in favor, please indicate by saying aye.
Aye.
Any opposed? Okay, and last, oh, yes, good, thank you. Lastly, we have a motion to amend so that it says, the county council, its individual members in their official capacity.
Elected capacity.
Elected capacity.
And I don't know if is this Maya's? I mean,
Actually,
Commissioner
does
Morales.
official capacity makes more sense?
But they have more than one official capacity.
I'm just, in terms of like, when you're somebody elect versus someone sworn in, does official? mean-
Oh.
Is that a tricky issue?
I don't know.
I'm
Yeah, that's a
using
good
too many
question.
legal terms here.
Oh, because I guess a county department would not be elected,
Oh, yeah.
so I think that's probably
In their
more
official
appropriate.
capacity.
Yep.
And Maya,
Official county capacity?
Location of this discussion is where?
we're clarifying the language on the amendment.
Was it, I think, we're okay. Sorry.
Okay,
Sorry.
that's fine. No, you're right.
Commissioner Morales, you're the maker of this.
Oh, okay, I'm motioning to amend, do I need a motion?
Mm-hmm.
Okay, so I would just motion to amend this to say the county council, its individual members in their official capacity in any county department or office, et cetera, et cetera. I would motion that we accept that as a, amendment.
Okay.
Thanks, right?
Yes, good. Is anyone opposed to deciding this by consent? All those in favor, please indicate by saying aye.
Aye.
Any opposed? Okay, at this time, I would like for staff to call the roll, and this is on a motion to adopt amendment 29 as amended to send to the voters.
Was there a second on the original motion?
There was, but.
Second, there is.
Was it John? Was it me or Hannah? I think so.
I think it might have been.
It was a long time ago.
Well, just a sec. Do we have to change in, 8.26, section 2? Also, you think we need to change that as well?
Good call here on.
Oh, yes. Right. You want me to motion that? Do I need to motion that?
That sounds like.
Okay, motioning to change section 8.26, number 2, to say the county council is individual members in their official capacity and any county department, yada, yada, yada.
Second.
Okay, is there any objections to deciding this by consent?
Are you also changing public funds to county funds there?
Oh, yeah, good
That's the
point.
next piece. There's 3 that we're gonna have
So
to
we
do.
vote on that and then go to the next one?
Incorporate that into your.
Okay, incorporating that and also to change the rest of that sentence to say, and any county department or office shall not expend county resources.
County funds.
County funds.
Use county resources, et cetera, et cetera.
Use county, yep, okay. What's the third thing we need to change? I can't
Nor shall the
remember.
county engage in actions intended to influence the outcome of the election.
But that's not
In section 1, it's right here.
Oh, and strike that line, okay. Is this what Commissioner Morales is motioning as well?
We're in section 2 right here. I'll do second. Okay. Is there any objection?
I'm sorry, I just got lost.
It's okay.
We got further ahead of this motion, and so I'm going back so we can get this part done, which is looking at section 2 and changing that language so that it reflects the same language as what we just voted to do in 5.62. We had Commissioner Morales as the mover. Who was the second on that?
Me.
Okay. Is there any objection to deciding this by consent? All those in favor, please indicate by saying aye.
Aye.
Any opposed? And that final one.
And then I'd like to offer a friendly amendment for section 1 to strike out, nor shall the council engage in actions intended to influence the outcome of the election.
Okay.
Okay. Any opposed to doing this by consent? All those in favor, please indicate by saying aye.
Aye.
Any opposed? Okay, good. Now we are back to a motion to adopt Amendment 29 as amended to send to the voters. This was a motion by Commissioner Ellenboss, seconded by Hannah Ordos. Zach, could you please call the roll? 1 second, just catching up. Sure.
Doug Chadwick,
Yes.
Eamon Collins,
Yes.
Liz Darrow,
Yes.
Joe Ellenboss,
Yes.
Lindsey Graham Ellenboss,
Yes.
Colton Coltonfeld,
Yes.
Brad Kelly,
Yes.
Maya Morales,
Yes.
John Muchler,
Yes.
Hannah Ordos,
Yes.
Joel Pitts Jordan,
Aye.
Andrew Redding,
No.
Jessica Rinstra,
Sorry, can you say that again?
Abstain.
Rod Stump,
Yes.
Jennifer Wright.
Yes.
That passes 13-1 with 1 abstention. Few more to go here. Next is proposed amendment 30 from Commissioners Ellenboss, Coltonfeld, or Ordos on requiring council members to hire dedicated aides. Are there any public comments on amendment 30? No. Would any of the commissioners like to speak to this amendment?
I've talked a lot. Somebody else wants to talk first.
Yeah, for sure. So I guess we would have to make a motion, a friendly motion to amend to the new language. So you'll see a little handout here, that has some updated language. based on feedback that we received from our colleagues, from elected officials and other folks, and I'm gonna try to be coherent here. Holy moly, I needed to be more before I came here. So the original motion, or the original amendment that we had made, simply stated that each council member shall hire a dedicated legislative aide who reports directly to that council member, and then council members can elect to hire a joint aide if they choose. Given the current budget environment that we are in, we're hesitant to make a mandate that the county spend more money. So in the language that we will amend in a second, following our rules here, we basically say that the county council, each council member shall be authorized to hire a dedicated legislative aide who reports directly to that council member, and that council members can elect to hire a joint aide if they choose. So basically, instead of making it a mandate, we're just saying, hey, you may be able to. Technically, they already can kind of do that, but it's a very, not a very popular thing to do, and this kind of just clarifies that role. It might be an opportunity for them to see what the public thinks about the idea. So
Motion?
I will motion, I guess, do I have to motion to adopt the old language and then one of you all can propose to, okay. I propose to adopt motion, proposed amendment 30, requiring council members to hire dedicated aides as detailed in the original packet.
Second.
And I will make a motion to amend that to reflect the language from our amendment 30 handout that Colton just read.
A second.
Okay. Commissioner Wright? Oh, I was just wondering if there was gonna be language about where the money comes from, because I heard that there was like a question about that. Did we end up needing to address that?
We don't know if there's a mechanism within here to address that.
I would just saying like, this shall come from the county budget or something, so that it's not like they're hiring it out of their own paycheck or something like that. Be good. I don't know, just a thought.
I think it's implied.
It's implied, okay. Okay. Just the question had been raised to me, so that's why I'm bringing it up.
Commissioner Morales. Yeah, I'm a little confused by the last two. I would like to second whatever I also +1 on that reason about money. And also the last, sorry, the last two sentences, a majority of the council shall constitute a quorum at all meetings.
That's already there. Our section is just starting at each council member to direct the reports to that council member. That's all we've added.
Okay, so the majority, those last two sentences are just part of the section. They're not part of your amendment. Okay, thank you so much for clarifying that.
Commissioner Redding?
Yes, I consulted with Kellen about this and also with county council members about this. And both Kellen and council member Scanlon and council member Donovan got back to me, and they all had essentially the same answer, that this would, there's no way to read this actually in a way where it would, what my fear was, that it would be incumbent on the council members to take this out of their own pay. That's not even possible.
Okay.
So I wouldn't be concerned about that, given all the responses I've gotten, and they're all consistent.
Okay.
I would ask that one other thing I'd like to do, because it's in the title, requires council members. I'd like to turn that to enables instead of required.
It does.
Okay,
On the
this just was
amendment,
mentioned.
yeah.
I just want to make sure we're
I
doing that. Yeah, as part of this process, and incorporate that in the amendment.
Do you mean,
That's okay.
do you mean the word authorizes? Should we use the same language? Should we, I'm just asking if when you're
Does that do the
proposing
same
that, do you
thing?
want to use the same language, like authorizes, isn't that what you changed it to? I'm
accept
just wondering
that.
if you want, I'm just asking Andrew, who's making this suggestion.
I'm okay either way. Enables is a simpler word for just a title. It's just a title there. But either way, whichever your preference is. I just want to move on. It's late.
Yeah.
Authorizes?
I think I can speak.
He's gonna
under
write
that.
whatever he wants anyways, he said.
That's true. We can set you up for success.
Yeah, I'll take that as a friendly moment on behalf of my colleagues.
Which word though?
From enabling to authorize, is that?
You mean requires to authorize?
Well,
Uh,
we already approved enabling and now
Oh,
we're changing,
Okay,
yeah.
so sorry.
Okay.
But yes, roundabout.
Authorizing.
I preferred enables because it's a simpler word, but you know.
I
if you
worry
want it, you
enabling
get
is
it.
like, has
I'm not
mixed,
gonna argue if it's like
enabling has
gay.
like a negative
Yeah, no, what time it
connotation,
is?
so.
We're nitpicking.
Okay. All right, so we have a motion to amend the title to authorize as council members to hire dedicated aides, and that motion was by Commissioner Redding, seconded by Commissioner Feltenfeld. Are there any opposed to approving that by consent? All those in favor, please indicate by saying aye.
Aye.
Any opposed? Okay, so we have a motion to adopt the proposed amendment 30 as amended. That motion was Commissioner Feltenfeld, and the second was Commissioner Redding. Staff, could you please call the roll?
So, are we voting on the amendment itself?
The actual deal, is that okay? Do you have more to say? Oh, go ahead.
Yeah, I said this last time, I will not be supporting this. I again think we're micromanaging the county council. They can do this tomorrow. We want to do that, the budget part, but I still think it's what we should do.
I'm a little behind. What was the mover and the second for that last motion?
For the one that we're about to vote on?
No, for the motion from enables. to
Oh,
authorize.
before that, the motion was Commissioner Redding, the second was Commissioner Feltenfeld.
Thank you.
Yes.
We never put in.
Yeah, I think it's better to not specify. Staff, would you please?
And this is for the main motion.
Yes. Is everyone clear what we're voting on?
Eamon Collins,
Yes.
Liz Darrow,
Yes.
Joe Ellenboss,
No.
Lindsey Graham Ellenboss,
Yes.
Colton Coltonfelt,
Yes.
Brad Kelly,
No.
Maya Morales,
Pass.
John Muchler,
No.
Hannah Ordos,
Yes.
Joel Pitts Jordan,
Aye.
Andrew Redding,
Yes.
Jessica Rinstra,
Abstain.
Rod Stump,
No.
Jennifer Wright,
Yes.
Doug Chadwick,
Yes.
and I need Maya Morales.
I'm gonna say yes.
Wait. Guys, come on. Did you come from
Yes.
Oh, all right, so, okay. And that passes 10-4 with one abstention.
Okay, so what is the vote finally?
Yeah, so it's not, I was like repeat loud. 10-4 with one abstention, that motion passes. Okay, moving on to, proposed amendment 34 from Commissioner Colton on establishing Whatcom County Office of the Ombuds. Are there any public comments? I felt like a long time ago we had one. Commissioner Bird in the general.
Yeah.
I have Sandy Brewer.
Council members, public, we've talked about this. This is one of the things that I ran on, and yes, I didn't get elected, but it's an office that's needed, and most of you in talking about this have agreed that it's needed. And so I just want to urge you to quickly vote to put this amendment on the ballot.
Thank you. Any further public comment?
That's all I have.
Sure. Commissioner Colton, would you like to speak to your?
For sure, yeah, I'll make this really quick. You all have already seen this. It's the same amendment that we passed before. If you direct your attention to the screen there, did not make the packet. At the very bottom, you can scroll down to the bottom. There's a small little paragraph at the end saying the county council shall place a charter amendment on the 2032 general election ballot, asking voters if the section shall be maintained. So the idea is that if we were to pass this and it's to, passes the voters, there would be a 2-year implementation period starting ending January 1st, 2027, where, the office will be set up, and then the office will have 5 years of functioning to prove its worth, prove its mettle, show some results for voters, and to build their confidence. And, if at the end of those 5 years, the voters have decided that the council, or that the office rather, my goodness, hasn't done enough to warrant their taxpayer money, they can vote to remove this section of the charter, a little classic sunset clause. That's in response to my colleagues who are worried about giving this office a blank check with no accountability. So just kind of a way to build in some of that accountability to voters. There's questions about, well, should there be like a formalized report, something to that extent? I would like to leave it open so that our council can decide what is going to be most appropriate for that office to do. But I would hope that if the person in that position really cared about their job, they would do a really good job building a report with all the cool things that they're doing. So yeah, I will make a motion to produce this language to the voters.
Second.
Commissioner Ellenboss.
Well, before I make my comments, I want to clarify, is this what was before us in the packet?
That is, well, not in this packet, but it was what was voted on at the last meeting, and it was emailed to you, I believe, this morning as this, but just didn't get included into the packet proper.
But this is what we voted to discuss and vote on.
That's
This
correct.
language, yes. Commissioner.
Okay.
Oh, sorry, it wasn't done. I'm sorry. 1 second.
So the question that I have is, I haven't seen that language before, but is it essentially saying that it's a 5-year period of time that they exist? And then it needs to be renewed? In other words, has it got a sunset in it per se?
Yes.
And then it gets renewed? Okay. It's good language. And I want to say that, well, I don't know whether I actually support this being approved. As I said before, it passes my muster of deserving to have the public's vote. And the main reason I say that, ladies and gentlemen, is that in my lifetime, my experience is that there are all kinds of people in official positions, they're not elected, in official positions in Whatcom County who are the worst enemies of the public possible. And they talk, and a lot of them are in planning development services in areas where they take significant freedom about denying us our rights based on their interpretation of how they want to do things. In my lifetime, and I'm just a little guy, it's been hundreds and hundreds of thousands of dollars over a 40-year lifetime. And unfortunately, when Pete Kremen was chair, or was the county exec, he would fire some of those department heads. I haven't seen anybody fired for failure to comply with the regulations since then. So again, I applaud your situation as you bring it forth. I almost was going to vote no based on your little tirade on the other issue, but this in its own face deserves to have our support and to go before the public for a vote.
Commissioner Mutchler.
Yeah, I'm still voting no on this for similar reasons as the last time it came around. And I don't think adding the sunset is helpful, because how do citizens know whether the office of the ombudsman has been successful? The office of the ombudsman, by definition, is dealing with a very small group who have problems with official or policy or something like that. That's going to be a very small handful of people. Are they going to put a video together and share their stories, or 60 Minutes going to come in? I just don't understand how the public is going to be capable of deciding this. Whereas, as I said before, the county council, they're elected, 7 county council members representing 5 districts, 2 at large. They're the ones that have their ear to the ground, responsible to the community. They're gonna know whether or not they need this or not, and they can figure out how to pay for it, so. I just don't think it's kind of just another way to build government up and give them a chance to use that bank capacity. I tried really hard to predict what tonight.
Commissioner Chadwick.
Thank you, Madam Chair. Again, I appreciate Commissioner Colton-Felt's work on this. Last time I was a no vote and I raised my concerns about exactly what Commissioner Muchler talked about is I wasn't in favor of necessarily creating other offices. And I want to point out for the record, and I think Commissioner Ellenboss cited it earlier, the council does have the ability to reallocate county resources. They can reduce staffing in departments, they can increase staffing. So I believe some of those resources exist. So I'm not looking this is potentially adding additional funding, hopefully, as that's rolled out. But my one concern, and you've addressed it, was I wanted that test period because I'm not 100% sure that this is gonna be as useful and utilized as much by the public, but I think this sunset clause does give the opportunity for it to go in front of the voters. I would hope that office produces some kind of annual report to show what type of work. We've certainly had some issues here within county government over the last year or two, where our legislative body and people that are making decisions about how to expend taxpayer funds are not included in these conversations. So I'm all for the accountability, the transparency piece. Like I said before, there were a lot of things that I liked about this. I just didn't like the fact that we were basically starting a whole nother office. We were talking about staffing, we were talking about giving them a new office. I'm a little, that hits a nerve with me when I've got people I used to work with that are in a basement with sewage falling down on them and they can't seem to find a building for them. So I would like to propose a friendly amendment that instead of a 5-year operational period before it's assessed, it'd be 3. I think that's enough time to get some numbers and see how this is being utilized. Hopefully that report is produced. So that would be my friendly amendment.
Second.
Commissioner Ray.
What if it was the annual reports for those 5 years? Because as a person like on the interior, as the Healthy Children's Fund's trying to roll out, I will say, you know, it will take them the 2 years to get it set up, and then you need some time to be able to make it a thing. So I wonder if it had an annual report and then at the end of 5 years. I love that it's in the hands of the voters, not the council. I don't know, I'm not making it yet, I'm just asking it about how that
I
goes.
think it is, we're looking at 2 years to implement, 3 years operational period. So a total of 5 years. I think originally Commissioner Colton was suggesting 2-year implementation and 5-year operational period. So it was a total of 7 years from start to finish.
Commissioner Stoll.
I don't think this, we're using the term transparency again. I don't think this creates transparency. I don't think you create transparency by adding more junk in the water. I think you remove stuff that's too complicated. I don't think we need this. I think we have an HR department. I think they're, like Joe said, we have a county executive. If he's not acting, get him out of there. We need a guy that hires people, not doubles his staff. Unless the ombudsman patches potholes, plows roads, digs ditches, arrests criminals, I'm not voting for this. This is like build a big government 101. This is just, nope.
Commissioner Morales.
I was pro this idea, and then I saw the first draft of this and was a little bit like, oh no, I think I support this, and now I firmly support it. And I also am hearing a concern raised about how will voters know, and it sounds like there's pushback though to having the council decide this, and so I'm gonna rest with that objection. I was gonna sort of second this idea that it might be not a terrible idea to friendly amend this into a council review of whether this is functioning appropriately, rather than a voter review, because I feel like most of the voters I know don't really have time to dig into the success of the ombuds via a report or otherwise, and I do worry that
that becomes an electoral kind of like messaging push rather than an actual real review of whether the ombuds office is functioning. I do see a ton of value in an independent legal office where people can go with their concerns. I don't think that's extra big government. I think it's actually a people's remedy, and a people within the government remedy. And so I guess I would like to know from the main sponsor, you know, would you be amenable to having the council review it? Would others? I'm just worried about voters having to make that decision.
Yeah, I mean, if I really had my way, it would just exist. But I do understand that, you want to be mindful about accountability. And I do kind of agree that maybe, a charter or a review from the council would be a more nuanced and like more perspective perhaps. But I think if we're talking about accountability and spending taxpayer money, it's probably better for the voters to decide on that.
Commissioner Mitchell?
I actually think it would be wise to, if this is brought to them, it should be the county councils that say, oh, the first weeks, they're gonna know. But I'm also concerned about advertising a job. It takes a lot of skill, professionalism. And by the way, my own last 3 years, you're gonna have a hard time recruiting professional people in a position when you have a sunset clause like this. The last thing I say is I think there are places to go if you have a problem. You've got human resources. Most of our jobs with the county are represented by a union, and they're there to help out. So a lot of these things can be taken care of. We've got commissions that can help out, board utilization, hearing examiner and such. So I just have a number of concerns with this.
Commissioner Ray?
I think your point about the sewage falling down, they can go to the ombudsman person, so it's actually, I was like, they know they have somewhere to go. So I think that it's like just crucial. If we want to have a effective functioning county government, we need people to have recourse, and if it was with HR, then that's like an internal reporting to the executive. Right, and if the issues are there, I think we've seen things come up where that is been believed to be an issue. And then what was the other piece? It's fading. Was important though. Oh, it was similar about the county council. Like I think giving an annual report to the county council, but keeping it in the public's hands to vote it in after, I hope 5 years, because that's a good point about the somebody won't be recruited to it if it's too short. Maybe that's a compromise, because the county council also might have complaints from people, and if they don't, I don't know. I just think like people in positions of power don't always like accountability. So I think putting it in the hands of the public, to me, makes sense, but a report to the county council annually, maybe we could amend it that way. I don't know, just thoughts.
Commissioner, proposing anything? I just had a couple of quick clarifying questions for the sponsor of this, if that's okay. I've tried to read back through this. Who creates this office? So it says by ordinance, but who?
County council would, by ordinance, during that 2-year implementation period, hopefully in collaboration with the executive and all the other various county departments.
So HR would find the person, and then the council would approve whom that person is? Or office, like who? That's what I'm trying to figure out. Who selects these individuals to be part of the office?
Yeah, so the county council has the power to appoint the position. It says the office shall be appointed by the county council, maybe from a nationwide search. But I would imagine it would be filled like any other role where we're looking for talent. The HR would be responsible for doing the job posting, and then council would probably dig through the positions.
And they don't but where do they sit? Do they sit in the legislative branch or the executive branch?
The legislative branch.
Okay.
Commissioner Mitchell?
At the very least, I think we should heed Councilor Commissioner Maya Okay, let the council have some authority to bring this to the end. They're the ones that have to pay for it. This could be $500,000 a year. 2 highly trained people, you're probably gonna need an admin, a secretary, some kind of office space, benefits, expenses and things like that. Nobody's identified where they're gonna come up with it. It could easily be $500,000 a year.
Okay, I just want to point out that we are right now, we have a motion on the table to adjust the sunset period from 5 to 3 years. Does anyone have anything to say about that?
I will note Jessica Veenstra.
Oh, I'm sorry, Jessica, I cannot
She's
see.
really little now.
Go ahead.
That's all right. Thank you so much. I don't have anything to address about the sunset period. I wanted to talk about the ombuds in general.
Okay, well, let's sort this thing first. We have a motion to adjust the sunset period from 5 to 3 years. That was made by Commissioner Chadwick, seconded by Joe Ellenboss. I think we're gonna need a roll call on this one, would you please?
Liz Darrow,
No.
Joe Ellenboss,
Yeah.
Lindsey Graham Ellenboss,
Yes.
Colton Coltonfelt,
Yeah.
Brad Kelly,
Yes.
Maya Morales,
Yes.
Too late, Ann.
John Mutchler,
Yes.
Hannah Ordos,
Yes.
Joel Pitts Jordan,
Aye.
Andrew Redding,
Just for clarification, is this on the main?
This is
motion
the
or is it an
motion to
amendment
adjust
that
the
was what
sunset
I was-
period.
Yeah,
Okay.
the sunset, bringing
Pardon?
it from,
From 5 years to 3
5
years.
years to 3 years, so 2-year implementation period followed by 3 years of the office actually running before it goes versus the 2-year implementation and then 5 years of it running.
So I thought it was 5 years to begin with.
It's, yeah, so it's a 5, originally, so it was 7 years, I guess, originally. So it was a 2-year implementation where the office wasn't running January 1st, it starts, and then there's a 5-year run time, and on the 5th year, it goes up on the ballot. This amendment from Chadwick would bring it, keep the 2-year, but then bring that down to 3 of actually running.
So when then come to the voters 5 years from now, from when it is adopted.
Yeah, I think it would be
2030
2030, yeah.
instead of
Okay.
2032.
Yes.
Jessica Rienstra,
Yes.
Rod Stump,
Yes.
Jennifer Wright,
Yes.
Doug Chadwick,
Yes.
Eamon Collins.
Yes.
Passes 14-1, and so we're back to the main motion to approve amendment 34 to send to the voters. Jessica, you had a.
Thank you. I appreciate that. Thank you so much, Commissioner Coltonfelt, for all your work on this. I always appreciate your really collaborative spirit on trying to make sure that it is addressing everyone's concerns. And I just really want to say that this office could be incredibly important. I think, as many have mentioned, we have run, most of us have run, I think all of us have run on the idea of ethical work, transparency, and accountability to the people. This is an office that upholds those ideals. It also is an office that has shown over and over again to be cost saving. And so while I don't know that the ombuds themselves would fill the potholes, I think there would be income that would be saved, value that would be saved that could be applied to other areas. I hear the concern about having a shortened period of time for somebody who may only be hired for 5 years. I've worked with a lot of grants nationally, locally. We have hired many, many excellent doctors, physicians, epidemiologists from all over the place. And in many ways, having that shortened timeline also kind of makes somebody prove their worth. So someone's going to be very motivated to do the job, to make sure that the office duties are being upheld, that they are looking for efficiency in government. And so I just agree very much with your presentation here, Commissioner Coltonfelt, and I appreciate the work that you've put in on this.
Commissioner Mutchler?
I move to amend the main motion in that the sunset decision of the sunset would not be the voters, but would be the county council. And if there's a second to the motion, I'll speak to it.
I'll second it for the purpose of discussion.
I want somebody to really know whether it's effective or not. I don't know how you can expect 150,000 voters to know whether the office of the ombudsman is effective or efficient or relevant. But I think the county council, at this point, they've funded it, it's up and running, they can tell whether it's running or not, you can have a better, more honest assessment.
Yeah, I'd just be curious to get Commissioner Chadwick's opinion, being the one who brought forth one of the friendly amendments and who was persuaded to back this in the end because of that. Would that be going in the wrong direction for you, or?
No, I mean, I certainly understand the concerns about how does the public know if it's effective or not. I mean, a lot of times we make decisions based on not so much the data, but how it makes us feel. So I think a thorough analysis, obviously, hopefully they're putting together good information, have good data to, one, see, is this effective, is making a difference? Is there a cost savings? Are we seeing a change in behavior? Because ultimately that's part of what we're looking for, is a government that is more responsive to the citizens. And that's really what your goal here is. So I'm not necessarily opposed to having the council do it, but I also don't want to take that decision away from the voters. We're voting to put this in front of the voters as something that they want. My thought was, I also want them to have the opportunity, now that you've seen, we've tried it for a period of time, is this what you want to continue to do with these results? So I guess I'd like to see kind of a, I like the analysis by the council, because again, he's right. They're the ones that are going to make the financial decisions on behalf of the taxpayers to continue. So I don't have a lot of heartache about that. If the voters want to put it there, and then it's up to the people that we put in office to decide if it stays, I guess I can accept that.
Commissioner Wright? Could we consider an amendment, I'm not doing it, I'm just asking about it, to your proposed amendment that creates an annual report to the county council and then puts it in the hands of the voters, since really the voters are the ones paying for it, right? Does that seem like a thing that you'd be open to?
I hear two things. You want an annual report provided, but you still want the voters to decide.
Yeah, because I think that it's the public.
Do we expect, honestly, the voters are gonna read that report?
I don't think the
The
voters
county-
will
the
read the
county
report
council may well read
necessarily,
the report.
but I think the media would read the report. I think it's gonna be something that gets a lot of
How many
attention, and that
people
will get out to
down in Herald now?
the public. Well, there's also a lot of other
Okay.
Commissioner outlets.
Well, one, I'm appreciating all of the dialogue, because this is a particular amendment that I've really struggled with. On one hand, seeing the value of the county employees having another outlet, because unfortunately, with the background in HR, I know that HR sometimes can fail at doing that, especially when they report to a certain branch of our county. So there's some conflicts that can happen there. And then the cost has always been a very big one for me throughout this process. If we move to have the council be the ones that make the decision, whether it's continued, if that friendly amendment is accepted, I guess my question would be, why wouldn't we want that council to decide on a supermajority? I think that would sit more comfortable for me, because then in order for it to continue, there would need to be broad support amongst the council that it's doing an effective job. And then I'll just throw out there the part about cost savings. It's kind of anecdotal. And then the part about reporting, what mechanisms do we have, or we could have the reporting necessary to make some of these decisions? And so I share these things because I want the body to understand that I'm heavily contemplating through all of this stuff in order to make my final decision.
Commissioner Wright? Okay, so one of the questions was about the reporting to the county council. And the report, you were saying, like, let the county council decide. If it's a supermajority, my concern would be, like, then what if you have not conservative or progressive or what have you, but you have like, you know, like, I don't know, it just seems like maybe there's some people who, there's issues with those people. I think it personally should be in the hands of the voters. That's me. Anyway,
So who's gonna, in 10 years when we come back, who's gonna be the overseer of the ombudsman? This is just just regenerate. This is just
county council.
government growth, and we're gonna need more and more and more. It's like, this isn't the answer. This is not the answer.
Okay, we have
Sorry.
an amendment so that the sunset clause would be the responsibility of the county council rather than the voters. Can we call the roll on that?
Joe Ellenboss,
So this is a question of,
This is an amendment to change the sunset clause decision will be made by the county council rather than going back to the voters.
thank you. Yes.
Lindsey Graham Ellenboss,
Abstain.
Colton Coltonfelt,
Yes.
Brad Kelly,
Yes.
Maya Morales,
Yes.
John Mutchler,
Yes.
Hannah Ordos,
Pass.
Joel Pitts Jordan,
Aye.
Andrew Redding,
Yes.
Jessica Ranstra,
Abstain.
Rod Stump,
No.
Jennifer Wright,
No.
Doug Chadwick,
Yes.
Eamon Collins,
Yes.
Liz Darrow,
Yes.
and I've got Maya Morales
Oh, yes.
and Hannah Ordos.
No.
And that passes 10-3 with 2 abstained. So now we're back to the main motion, which is to approve amendment 34 as amended to send to the voters.
Just curious,
It's okay. go ahead.
what exactly does that language
Yes.
we just voted translate to? Just thinking about this, do you write down language?
Yeah, the amendment was, that the responsibility of the sunset clause would go to the county council rather than to the voters. So that was what we voted on.
I see, so it would say, gosh, whatever, the county council shall place a charter amendment on the 2032 general election ballot asking voters that this section shall be maintained. Decision to write.
Me, okay, so this is a good point of clarity because we just voted for it to not to go to the voters.
Yeah.
So the county council would make the decision.
So the county council shall decide whether to place a charter amendment on the 2032, or getting rid of it all
They will
together.
make the decision.
Okay, so the county council shall determine, in 2032, the county council shall determine whether this section of the charter shall be maintained.
I think it would actually be by 2030.
2030, sorry,
Yep.
sorry. Working off 0.
That math. Okay.
It's late, but
All
I
right.
can still do a little math.
Okay.
Do we want to add? Commissioner Coltonfeld, sorry to interrupt your cooking, but do we want to, we don't need to keep going tonight, yeah, seriously. But do we want to include something about them doing a report, an annual report?
Yeah.
Or not? I'm asking because it's been brought up and it.
I think that's probably fair. I can say, I suppose we can throw a sentence. How about we just throw something, at the end of the second paragraph, where it says the office shall use generally accepted standards for similar offices. What do you think about, each year, on December 1st, maybe, the office shall prepare a public report to council reporting on the work done by the office?
Present or prepare, present, it'd be like submit,
Submit.
okay, that's fine, I just was bringing it up because other people have mentioned it, so if we're good with that, I don't know if there's a vibe check.
Commissioner.
Thank you, Madam Chair. I think most sections of this nature typically are worded as the office shall report to the, in this case, the council, on the activities of the office or something to that effect.
Comma and report to council on activity.
Commissioner Allenboss.
Madam Chair, I'm sure I'm not the only one, but my day started at 5 o'clock. It's now 17 hours. There seem to be a couple of questions on this. I would move that we lay on the table this and the remaining business to take up on the 26th of June. There's no reason why it can't be done.
Well, I love that idea dearly. I'm told this is our last opportunity to vote on the timeline that we have.
I heard somebody say that earlier tonight. Why is that? How is that?
The reason is that it has to go, we have to go send all the items to, first we have to have a legal review, then we have to send all the items to the public for a certain amount of time to get pro and con committees. Then we have to have those pro and con committees elected by the council to serve. We have to have all of it done by a certain timeline to get to the auditor. We gave you this timeline a long time ago.
Commissioner Chadwick.
Thank you, Madam Chair. As far as the language about directing the reports, I don't know that that's necessary. I kind of feel like we're micromanaging the council. They're gonna write that into the ordinance and it's, they're gonna want information to make a decision.
Okay, we have a
Can I
motion.
call the question?
Yes. You don't even need to, because I'm sensing you're ready to vote. I'm sensing I'm ready to vote. Motion to approve amendment 34 to send to the voters. Staff, will you please call the roll?
Did somebody second?
Oh, yeah, as amended, thank you. Yeah, well, this one was already motioned by Commissioner Colton and seconded by Commissioner Pitts Jordan. This is the original motion. I'm asking for a roll call.
Lindsey Graham Ellenboss,
No.
Colton Coltonfelt,
Yes.
Brad Kelly,
No.
Maya Morales,
Yes.
John Muchler,
No.
Hannah Ordos,
No.
Joel Pitts Jordan,
Aye.
Andrew Redding,
Yes.
Jessica Ranstra,
Yes.
Rod Stump,
Nope.
Jennifer Wright,
Yes.
Doug Chadwick,
Yes.
Eamon Collins,
Yes.
Liz Darrow,
Yes.
Joe Ellenboss.
Yes. I barely could get that
That passes
out.
10 to 5. Okay. We've got a couple more to go here. Thank you everyone for your patience. Next is proposed amendment 35. I'm gonna pass the gavel, to speak to this one. Myself as well as Commissioner Pitts Jordan and Rienstra. I'm changing the timeline of the Charter Review Commission. Do we have any public comment? No. Oh, I guess you actually have to.
Do we have any public comment?
No.
They're all in bed.
Okay, well, I'm gonna keep this really simple. We talked about this at introduction. The concern that I have, that brings me to clarify this language in the charter is that I had no idea that we were gonna be on this timeline, and I feel like it's just been, it's been a lot. And that's why we find ourselves here at 10:15 at night, when I'm sure we would rather not be. So to give the commission a full 12-month term, I think would do justice to the work that we are all putting in and that the public is putting in to do this process every 10 years. There were some questions brought up about the section 8.21, the sentence reading, the commission may propose amendments, et cetera, et cetera. This shall admit the amendment to the voters at the next general election following the end of the commission's term. There were a couple of commissioners who didn't like that, because what that would mean is that we're sitting here now making decisions until December, if this were to be in effect, and those, the amendment package wouldn't go to the ballot until November 2026. And I hear that, and I'd be willing to strike that sentence. What's really important to me is if I'm running for office or if I'm electing someone to office, I want to know what their term is going to be. I want to understand what the purpose of that office is, and I don't want to see it rushed more than 50%, because it's not clear that the commission will meet for a full 12 months. So removing that sentence, to me, there does remain to be some ambiguity about like, well, when then would the amendments go? Could they go twice? That kind of thing. Like, I don't feel comfortable with that, but it's not in there now. Adding it seemed to draw out the timeline more than some people were comfortable with. So I move that we approve proposed amendment 35 to send to the voters.
Second.
Thank you. and happy to entertain an amendment to that, language in 8.21. If the body would like to do that. Go ahead.
Yeah, I would make that motion for that amendment. I don't know how to word it, but my intent is that the commission would work 12 months. When they are ready for the first batch of amendments, they go to that next general election. And then when the next batch is ready, probably a smaller batch, they will go to the next one. So remember, a charter only meets every 10 years. So you've got 2 years of amendments. And look, we've got quite a few here. It might be a gift to the voters to maybe just have to swallow half. So I don't know what the language is, but I think we should be able to use 2 elections. Why not?
Can I ask a follow-up question? By removing that, the pink language that I proposed, I personally, I feel like that gets that done without getting too far into the weeds. Because it doesn't stipulate which election it has to go to. It just says the next general election, the next November general election. So in theory, we could do that right now. It's just that it's not clarified in the charter. And so the assumption was made and has been carried through that we're done with our work after tonight, basically. Go ahead.
In previous meetings, I thought it was you, someone raised an issue of wanting to ensure that there wasn't like a meddlesome situation with charter amendments post-election, and I can't totally remember what the example was. Do y'all remember this?
I do remember.
Did we resolve that that would not happen?
I don't remember who raised that concern. Was it
Well,
like,
the concern was mine originally, that's why I wrote that, because I didn't want to have a tug of war with, like, for political reasons. And it was also pointed out to me that there's nothing that prevents us from opposing charter amendments, even in the same package to voters, which I think is bonkers, and I'm glad we haven't done that here. But it could be done, and it has been done. So I don't know that we can really see forward into the future, like, hopefully the intent of the commissioners won't be to mess with each other in the public like that, but I have to say, in all honesty, after thinking about it a lot, I think it's too much to ask voters and commissioners to wait a full 16 months. Like, that's just a lot to ask. So I'm willing to just strike that if that's allowed. But I just wanted to I wanted to hear from commissioners about how that feels to them. Because really what I want was clarification. Like, I thought I was running for a year-long term. And that isn't what we have ended up doing. So that's why.
Commissioner Muchler?
Was there a second to my amendment? Seconded it. Because I think we should deal, and my intent is that there would be language so there wouldn't be ambiguity. I'm not sure what the language is, but it's clear what I'm intending.
Shall we,
Wait, what's your motion? I'm sorry if you're not sure what the
It's
language
okay,
is.
we're tired.
It's just to strike exactly what you said.
Oh.
But add language that says that the commission can use 2 elections. If they continue working in August, September, October, then, or they've got the next election 12 months later.
shall we say,
I'm gonna withdraw my second, and here's why. Because I think it's implicit already, okay? Because the very fact is it goes to the next November election of whenever it was adopted.
Right. Or still in motion.
okay, so shall we take a vote? Do we have more comments? Wait, what now?
He just withdrew.
Oh, he just withdrew.
But I'd like to make a substitute motion to just remove that one part that you suggested.
Second.
Can we have some clarity about what the one part is?
Yeah, it's the pink sentence. It says following the end. Oh.
8.21.
On page 33. Second line, end of the second line.
I think that'll work.
Okay, so the motion is, and second are to strike the words following the end of the commission's term. Yes? And
that was moved by Reading and seconded
by Israel. Commissioner Muchler?
Thank you. Here's my concern. The original language uses singular subjects, next November general election. You could argue there's one election in mind there. We're talking about the possibility of 2 elections.
So could we say like it's under the discretion of the commission whether to submit it as one package or over the course of 2 elections, or do we not want that specificity? Commissioner Redding?
I would say at the next November general election following adoption of each, of the various,
And I would strike it.
proposals.
Just say the November election following.
November.
The key to this, bear in mind, is that what gets it on the ballot is turning it over to the county council. So, there's, if you turn it over to the county council before the July date, or evidently before, or the decision is rendered before June 16th, then those items will go to them and will be submitted in that election. If there's action taken after that, it would likely go into the next year. But the query that I have, knowing human nature, is that by stretching this out 12 months, we're just gonna be rushing in September and October when football season starts, and there's other important things. Because we won't make the decisions early. And I'm including myself, because I think I can still do it at 86 or so. Given the whole county doesn't go to Democrats, I might have a chance to get elected. So, the question is that why we're undertaking this, or is this just for clarification because some thought that it was a year-long term?
Well, it is a year-long term, but we're not being allowed the timeline to serve for a year. And so I feel like that has created a 10 years body of work, like to be really squished. It feels fast to me. That's why I'm doing this. I think the voters deserve a full year's worth of work on a once every 10 years process.
Okay, so we are moving to strike following the end of the commission's term. And are we inserting anything or not? I don't know what we're doing and what the words are, so can you tell me if we have words? Commissioner Muchler?
I'm asking the question of the body, is there, basically, if we don't, we're probably pushing everything a year and a quarter in election. Or are you interested in doing this election additionally the following election? I'm comfortable with that, but I'm not reading the group yet.
Commissioner Collins?
Yeah, to that point, I think you could insert words, the commission may propose amendments to the charter at any time during its term by filing such proposed amendments, and then everything else stays the same. If you want to make it possible to kind of propose batches of amendments to go on one ballot and then another.
Can you tell me those words again?
Yes, the commission may propose amendments to the charter and then insert at any time during its term.
How about during?
At any time during its term of office.
12-month term, of course, of its 12-month term, or just of its term? Term. Okay, it's implied. But do I say 12 months or do I not say 12 months? Just like.
Of its term.
During the course of its term, okay. All right, so is there more discussion needed, Commissioner Morales?
Well, we had the addition of did you get the language of shall submit the amendment to the voters at the November?
The November election, right?
Are we leaving that as is, or are we amending that slightly?
Right here.
General election?
I thought we were just amending it slightly to indicate that it would just go to the election following the submission of the amendment. Are we not needing to do that anymore? Just
I
clarify.
think the language that Commissioner Collins proposed does that. Because if we could do it at any time, it'll just be the next general election. That's what I think.
Can you read that?
Do I need to strike something then though? Because it says to the voters at the next November general election. I thought we were striking the word general. So do we need to strike at the next election?
No.
It has to be
At the
done.
next.
These have to be done by motion and voting. We had a motion at one point in time. to strike
Okay.
all
I
of
don't
them.
know. I'm lost and
I'm
it's
not
really
sure
late.
that's-
Can you please?
I would have moved an amendment.
Can I give it to you? Oh my God.
Joel. I don't think it's
Or Joel, I can't I'm really tired right now. I've been up since super early. I can't. Well.
Well, we could practice what we do, the charter says that what we've done now gets sent to the voters in November, and then we can come back. We could, because it's some more stuff, and then that stuff gets moved to 2026.
I think we're really close.
I think what I'm hearing is an intent and would, I guess, entertain a motion to amend the current language to say that the commission may propose amendments at any time during its term, or to the charter at any time during its term by filing such proposed amendments with the county council, who shall submit the amendment to the voters at the next November general election at least 90 days after filing and registration of the amendments. A supermajority 10 of 15 of affirmative votes or of the entire membership shall be required to file a proposed amendment with the county council. Is that?
So moved.
I will second.
We have a motion and a second. Is there a discussion?
Sorry, that's way too fast for us to follow.
Sorry
We
about
need
that.
to slow down.
Sorry about that.
So does this supersede Reading's amendment?
I think it's on top of.
Okay,
Right.
and all you're doing is changing it any time during the course of its term, that's it.
Great, thank you.
And striking that, yeah.
Is that one motion? Those
think
two
it's-
items?
I think there's, and there was an amendment on top of the original motion. This is an amendment on top of that amendment.
Okay. Thank you. Is it incorporated or?
Incorporated.
Yeah, I think we can incorporate.
Okay.
That's why I was like, letting it go.
Okay,
I found
Commissioner
myself
Elmo.
building a one thing.
Yeah, point of order, this is maybe one point where historics come into focus. The charter, the original board of freeholders selected this process to take place in a county election year, not a state and federal election year, just because it's a shorter ballot. And so you're talking about proposing to put something on the year when state and local, state and school board members and federal offices and all those are elected. That's also the one where all those legislative referendums and so on come in, and there's a whole series of the length of those. It's pretty extensive. Our analysis at that point was that the county ballot is less than half of the volume of the state and federal election. So one needs to bear that in mind too, as we're looking at what we're throwing out there. And that's probably more than anything what drove this, the deadlines of mid-year to get that taken care of, because government folk take so long to get it ready. I mean, that's just history.
I would just point out that the charter enables the county council to place charter amendments on the ballot in any year. So obviously, the people who put together the charter thought that was okay, so I don't think this is a serious impediment.
Love both of these points, would love to vote on this.
Seeing no further discussion, is there any objection to doing this by unanimous consent for the amendment? Amending the amendment.
I've got a question. I mean, you're doing a good job, but how did you get in that hole?
Great.
It's an amendment that I authored and I passed to my left and was like asked to pass.
I'm just really tired, Joe. If you think I should take it and do it, I will.
But there is a procedure for having him have the gavel, but it's not just somebody passing it to him.
Oh,
I would have preferred you to pass it down to Doug, because if anybody argued with him.
I will take it back. It's fine. Here, I'll just do it. It's fine. I'm just really tired.
Same.
I'll just do it. Okay.
I would move we suspend the rules and allow the chair to recognize Mr. Fitzjordan as our temporary chair for the balance of the year. You need to get that. You can't do that kind of stuff without, just by will.
Yeah, fair
That's
enough.
fine.
We have a motion on top of a motion on top of a motion. So.
Hold on,
I don't even know. Or what are we voting on now? This is why I'm like so tired. Commissioner
Before we
Overdose.
call a vote, I'm just asking that we restate whatever motion it is that we're
Okay.
supposed to vote on.
So are we voting on passing the motion or?
The amendments and we're on the main motion.
Okay, so are we on the main motion?
We did not, and we are not.
The motion as I have it is to add, is to strike following the end of the commission's term, the pink line. And in addition, add to the beginning of the sentence, at any time during its term. So it would read, the commission may propose amendments at any time during its term to the charter by filing such proposed amendments with the county council, who shall submit the amendment to the voters at the next November general election, strike, at least 90 days after the filing and registration of the amendments, and then it will.
Okay, and then are we ready for a vote on that now? Is there any objection to doing it by consent? Okay,
So that,
all those in favor say aye.
Aye.
Those opposed say nay. That passes 15-0. Okay, what's next? Can I pass it back to you now? Are we done with your, are we still
I
on
did-
this?
Go to the main motion now.
Yeah, we need to do the
Go to
main motion. Okay, so
And then
let's,
we have a motion over here to pass the gavel, so we're
Okay.
almost there, let's go.
all right, so the main, let's have a vote now on the main motion. And what was that? Sorry. As amended, can we please call the roll?
Colton Belt,
Yes.
Brad Kelly,
No.
Maya Morales,
Yes.
John Muchler.
yes.
Hannah Ordos,
No.
Joel Pitts Jordan,
Aye.
Andrew Redding,
Yes.
Jessica Rienstra,
Yes.
Rod Stump,
No.
Jennifer Wright,
Yes.
Doug Chadwick,
No.
Eamon Collins,
Yes.
Liz Darrow,
Yes.
Joe Ellenboss,
No.
Lindsey Graham Ellenboss.
No. Okay. That motion failed 9-6. Okay, yes, please.
Commissioner Ellenboss, I loved your motion because I'm about to speak to another. Could you please restate that motion?
Madam Chair, first I move we suspend the rules.
Second.
Do you have more to say about that?
No,
Why are we suspending?
not a debatable item. So just go ahead and see whether or not we go on with it. If we do, then I'll make a motion to,
Yeah, okay.
I think you can make a joint motion to suspend the rules and pass it down.
Are you telling me that you don't have to say what you're suspending the rules about? So we need to vote on suspending the rules without knowing what you're gonna say next.
I'll try to accommodate you. Madam Chair, I move we suspend the rules to accommodate the temporary passage of the gavel to Mr. Fitzgerald
I'll second that.
for the balance of the meeting, for the balance of the meeting.
I don't know if it's be the balance, meeting.
I think
It's just one more item.
As I said, I'll try to accommodate you, whatever you want it to be.
Yes, please. Okay. Is there any objection to deciding this by consent? All those in favor, please say aye.
Aye.
Any opposed?
Aye.
Proposal 36, do we have any public comment on proposal 36?
No. I see one. Benny Spencer. Please go ahead, you have 3 minutes.
Hi, can everyone hear me?
Yes.
Hi, thank you. My name is Benny Spencer. I'm a lifelong resident of Whatcom County. I want to thank all the commissioners here for their service and meeting over really long hours to do some really sticky deliberation, even in conflict with each other. And I especially want to thank Commissioner Liz Darrow for her work serving as chair and putting a lot of energy into facilitating this meeting, which has been considerably packed. I know everyone here is very tired, and I really want to thank everyone here for taking the time to listen to my comment. I wanted to express my support in the proposed Amendment 3 in places where the charter means that you must simply be present in Whatcom County in order to have a privilege or a right. It is more appropriate for the charter language to be changed from citizen to people. People have a right to safety and life-saving resources regardless of if they are a citizen. People have a right to work to feed their families and their communities regardless of if they are a citizen. I also want to note how incredibly difficult it is to become a citizen in this country and in this state. Changing the wording on the charter from citizen to people would be a tangible act by this commission to act with integrity within the understanding that all people are deserving of having access to safety and pursuing happiness and a sense of community. I want to know, I was at the meeting for the first half of the meeting tonight, and I did feel a sense of injustice being a mixed race person and being in a room full of people reviewing and amending a constitution that will impact all the people of this county, while all the people in this charter review are seemingly white. And if we're talking about maintaining integrity and accountability to the people, which has been emphasized many times during this meeting, I urge the charter to listen to what the people want and need. And right now, there are a lot of people who are scared and at risk of being kidnapped by ICE and separated from their families by ICE. And changing the wording from citizen to person on this county constitution wouldn't be enough for acting in solidarity to support and protect undocumented people, but it would be one step that the charter could make towards accountability and integrity for the people of Whatcom County. And that's all I had to say. I forfeit whatever time I have left. Thank you.
Thank you. Any further public comments on Amendment Proposal 36?
I do not see anyone.
Perfect. Commissioner Darrow, would you like to speak to your amendment?
Yes, thank you, and thank you, Benny, for that comment. So this is a tricky one because I know we have pretty differing views on this specific issue on this commission, but I would remind the commission that we are a nonpartisan commission, and what's really important to me here is that the meaning of words matter. Oh, wait, okay. So what we're saying in our county's constitution matters, and we should say what we mean. And so I did take the point of Commissioner Redding from the introduction. We talked about this, and there was a section where I had removed the word citizen, where I put it back in, and that is in 4.20, where it talks about each county officer holding elected office shall be a citizen of the United States and a resident and a registered voter of Whatcom County. You have to be a citizen to be a registered voter, so that's why I've taken that out, but I can also understand how that could be interpreted to be politicizing something that doesn't need to be politicized. Because you do literally have to be a citizen to run for office and serve in an elected official role here in Whatcom County and in the state. So that's fine. That's what that means. It says citizen and it means citizen. So I think that's great. There's other places where it says we the citizens, for example, of Whatcom County, when even our US Constitution says we the people. And that's because everyone who is born here has certain unalienable rights. And so you don't have to be a citizen in order for those rights to cover you. Same thing in Article 1, powers of the county. Those are people's rights. They're not citizens' rights. They're not just for people who have citizenship status. I went on to strike the word citizen where it says the rights of the individual citizen shall be guaranteed. The rights of the individual are guaranteed under the Constitution of the United States. Someone brought up the Bill of Rights. There's no place in the Bill of Rights where the word citizen appears. Someone brought up the Second Amendment. There's no place in the Second Amendment where the word citizen appears. So I think we should just remain committed as an elected body to matching the language to the intent and the meaning. And that way there's no confusion about at what point am I required to be a citizen in order to have these rights. The only place in this article where that's a requirement is to be elected to office. So that's about. Oh yeah, I move, thank you. I move that we adopt proposed amendment 36 to send to the voters.
It has been moved and seconded that amendment proposal 36 be approved and sent to the voters. Discussion. I see Commissioner Ellenboss.
Yes, I don't see any rationale for what's proposed under Article 6, Financial Administration, to strike the word citizens there, because the arguments you presented in the first two parts really have no bearing on an individual's ability to be part of this salary commission. They should at least be citizens.
Well,
Commissioner Wright.
yeah, I'm pretty sure our county actually voted recently that you shouldn't have to be a citizen in order to serve on commissions, like to be an elected official you do. But I think our county voted for that. And so these really are just bringing us in alignment with the Constitution and with the laws of our
Not as
county.
it relates to distributing county money.
Any board or commission, I believe. I think it's our county's
Is that something that
rules
we
at this
can,
time.
is that something we can ask the legal counsel to look into?
I can look into it, but I don't know the answer offhand.
The salary commission is selected by lot from the voter rolls.
Oh, by lot from the, okay, then maybe we do have to strike that particular.
I left that part out.
Shoot, okay.
Commissioner Morales?
Chair. I just wanted to say that I think there, to me, it just feels like a redundant word, not so much that it changes anything, because I feel like the fact that the salary commission is chosen from the voter rolls, et cetera. I don't know. I don't think it actually changes what happens. I think it just removes an extra word. So to me, I'm not bothered by taking citizens out there. I think maybe this phrasing is a little antiquated, and that's why it's like that. But I don't think it's necessarily changes.
I would move to strike it. So I would move to take that last portion of your proposed amendment out, to take the striking line out of there and just leave that language as it currently is.
Second. Okay, it has been moved and seconded to strike the word citizens from section 6.1, or strike the strike of the word citizens from section 6.100. Discussion. Seeing no discussion, is there objection to doing this by unanimous consent? Seeing none, all those in favor, please say aye.
Aye.
Any opposed? Seeing none, that amendment is, the amendment to the amendment is adopted, and we turn to the main motion. Further discussion? Seeing no further discussion, we will proceed to a vote on Amendment Proposal 36. Staff, will you please call the roll?
Colton Coltonfeld,
Yes.
Brad Kelly,
No.
Maya Morales,
Yes.
John Muchler,
Yes.
Hannah Ordos,
Pass.
Joel Pitts Jordan,
Aye.
Andrew Redding,
Yes.
Jessica Rienstra,
Yes.
Rod Stump,
Nope.
Jennifer Wright,
Strong, yes.
Doug Chadwick,
Pass.
Eamon Collins,
Yes.
Liz Darrow,
Yes.
Joe Ellenboss,
No,
Lindsey Graham Ellenboss,
Pass, I guess.
Hannah
I don't
Ordos,
even think anymore.
No, I know.
Hannah Ordos,
I changed, I know. No.
Doug Chadwick.
No.
Motion as failing 9-6.
Okay. One more. Finally, we have proposed amendment 38 from Commissioner Morales on updating the Whatcom County Charter preamble. Are there any public comments on amendment 38?
I don't see any, no.
Commissioner Morales, would you like to speak to your amendment?
Sure. So this is a pretty simple amendment. It's not very long, for me. It basically just adds in some of the words that I think we've stated as our values. It adds in a recognition of the original peoples that, have lived here. And it updates this to say all love its people, to just be more inclusive of everybody who's here. And so the whole sort of goal of this is to just flesh out this preamble a little bit more, to sort of give our intent for this charter process and for our charter. I'm hoping everybody's read it. Should I read out loud? Are you good? I think that no is a no, don't read out loud. Okay.
And then there's the addition of county government in the very last sentence, just to sort of like clarify that we're talking about a county charter and not our entire government. And that is it. So I would move that we adopt this amendment to update our preamble.
Second. Oh, Commissioner Ellenboss?
Yes. Recognizing the fact that every household in this county is currently being sued by our original people, who, when we gave them money for an aquifer, a Lummi aquifer, they.
Commissioner Ellenboss?
No, I mean, that's, they did
Is
not.
this directly
preserve-
relevant to the motion to adopt Amendment 38?
These are pertinent to, you're stating in here that we should include people in here who are suing everybody in the county as it relates to water rights, who have not undertaken, in my impression in any news media, the care for this area.
Okay.
And,
This is
okay,
absolutely, I'm sorry, I'm not hosting this. Make your point, please.
I'm totally opposed to language that says things that aren't necessarily true.
Okay, me too. That's why I gobbled you. So please make your point. Commissioner Redding?
I'd like to offer an amendment. And the amendment is to strike "in sovereign nations whom," and put just who there. Correct, this is a grammatical thing, whom should be who. So to strike that, and also, and then when it goes to "and all of the living beings," oh no, I'm sorry, not that. And then in the third line, government, a duty to govern is inherent in, I would strike all of. And then in the 1, 2, 3, 4, 5th line, it's where it says inspires confidence, institutes transparency. I would strike institutes transparency, invites public input. The reason for striking that last one is that's already covered by an accountability to the people, covers that. And the reason for striking "and sovereign nations" is because both Lummi and Nooksack have indicated to us they don't want that in there. And so I think it's very essential that we recognize that request. It would still leave recognizing the original peoples who have always cared for and stewarded these lands, waterways, and all the living beings it sustains would stay in there. Yeah, and then we, the people of Whatcom County, in order to have a government which advances justice, promotes the general welfare, inspires confidence, and fosters responsibility and accountability to the people, do adopt as the foundation of our county government this charter. That would be my amendment.
Oh, wait a second.
It should have a second, else it doesn't go anywhere.
Second for discussion. Go ahead.
I would accept the latter of those changes as a friendly amendment and would respectfully request to keep "and sovereign nations who." Reason being, because I'm hearing you saying that there was objections, but those were regarding a different amendment. Those were about treaty rights in a different amendment, and so this is not that. And so unless you have independently consulted them, I know I have, and so I don't. I would not accept that amendment unless you had on good authority more recently than I have.
My understanding was they don't want any mention of sovereignty in here. For various
That
reasons.
is not my understanding. So
I would not accept that as friendly, but I would accept the others as friendly. I think they tighten it, so I would like to do that, if, do I
I
need to
will
motion
still,
that?
yeah, well, no, you can accept those parts and I will still maintain my motion then to remove the other part.
Have a motion and a second. Is everyone clear on what the language change is, or do you want me to read it?
Did someone second that?
I seconded it for purpose of discussion.
Thinking to it. The sovereign nation language is problematic in that we want to recognize that sovereign nation language when they feel that they are superior to us. They don't have to
Okay,
pay our,
this
they
is
don't have
absolutely,
to, they don't have to pay the taxes.
it's
They don't have
unacceptable.
to comply with those laws. Those are not things you gavel a person out for.
I will just, I am in agreement with what Andrew said. I'm under that same understanding. I've had multiple conversations to research ways that we could be making sure that we're not missing something in this. I'm sorry, my brain, I'm tired. And I am not to the conclusion that this is something that is being asked for. And when I take out these amendments and read it as it is, I don't feel like we're just eliminating any groups of people, that we're being discriminatory, and that it's a good document and it's speaking. So I'm gonna stand with the original document, original preamble.
We have a motion to adopt the language here, removing and sovereign nations, removing the M from whom, removing all of, and removing institutes transparency invites public input. Can we have a roll call on that amendment, please?
Brad Kelly,
We abstain.
Maya Morales,
Okay with that, yes.
John Mutchler,
No.
Hannah Ordos,
So this is a vote on the amendment, not on the main motion. Yes.
Joel Pitts Jordan,
Aye.
Andrew Redding,
Yes.
Jessica Rinstra,
Yes.
Rod Stump,
No.
Jennifer Wright,
Yes.
Doug Chadwick,
No.
Eamon Collins,
Yes.
Liz Darrow,
Yes.
Joe Ellenboss,
Yes.
Lindsey Graham Ellenboss,
No.
Colton Kaltenfeld,
Yes.
Okay, so that language has now been amended. We'll go back to the original. Motion to adopt amendment 38 as amended is sent to the voters. Can you clarify?
Yeah, what's?
Okay, so we have now changed it. It's pretty sure, I'll just read it. The language now reads.
Yeah.
Treasuring the many wonders of our unique environment, recognizing the original peoples who have always cared for and stewarded these lands, waterways, and all of the living beings it sustains, and realizing that the power and duty to govern is inherent in its people, we, the people of Whatcom County, in order to have a government which advances justice, promotes the general welfare, inspires confidence, and fosters responsibility and accountability to the people, do adopt as the foundation of our county government this charter. Can we have a roll call, please?
Oh, I got a comment. I don't think this is right. I don't think. I went to high school with the Lummi Indians. I went to Ferndale High School, and before they had a Lummi school, they all went to Ferndale High School. And Zach probably went to Mount Baker, played football with them, we grew up with them, friends with them. And if I talked to some of my buddies like that, my Lummi friends, they would like probably punch me in the nose. It's very patronizing, very condescending. They're not victims. They put their boots on put their pants on one leg at a time, just like I do. They earn a living, they work hard, they don't need this. And I'm pretty sure they asked not to have this in there. So that's where I'm at with this. I'm gonna vote no for it.
I just wanted to explain why I'm voting no for this. A couple of years ago, I sat down with an individual that was on the Charter Commission in 1995 when they made the adjustment to what we currently have. And he was so proud of being in a participatory group where they came up with some of these changes specifically around advances justice, that he gave me a copy of it. And I carried it with me the entire time that I ran for council because I was so moved by the intention of it, and the collaborative environment in which the charter came together to make it. And so I appreciate as it is. I think that it gets across the intentions that we want our community members to know. And but I wanted to show why I won't be supporting it.
I want to kind of explain what this adds. I think it adds the accountability piece that we've built in, because I've seen so many of us come to a consensus on we need more accountability. I think that adds this into the preamble in a way that is helpful. A preamble essentially frames, here's what you're going to find in this document. I think adding that in there is great. I also think that we've added promoting the general welfare as really a way to show that we want to include everybody, right? That we want everyone to be well. We've done some things here tonight that speak to that, like the housing stuff, like the making sure that ballot initiatives can't be blocked by council, things like that. And so I think in terms of recognizing the original peoples, that's really about recognition. I think we all are very much aware that we live with other nations and that we, as you said, you know, have a range of life experiences being in proximity to overlapping nations. And so for me, this is really just about acknowledging that and also acknowledging what we've added in this charter and helping us frame that. So.
All right, seeing no further comments, staff, could you please call the roll?
Maya Morales,
Yes.
John Muchler,
Abstain.
Hannah Ordos,
No.
Joel Pitts Jordan,
Aye.
Andrew Redding,
Yes.
Jessica Ranstra,
Yes.
Rod Stump,
No.
Jennifer Wright,
Yes.
Doug Chadwick,
No.
Eamon Collins,
Yes.
Liz Darrow,
Yes.
Joe Ellenboss,
No.
Lindsey
no.
Graham Ellenboss,
No.
Colton Kaltenfeld,
Yes.
Brad Kelly.
No.
Failed with 8 in favor, 6 opposed and 1 abstained. Okay. We did have an item moved to the end of our agenda many hours ago. I would entertain a motion to move that one to a later meeting.
I think we have to consider it.
Let me see if I can dig it out from my pile. I thought that it was for rescinding something.
I think if we want this to go to the ballot, we have to vote on it tonight. Correct?
Oh,
Yeah, but this is not long or complicated. And I think we can, I'm happy for us to just move straight to the ballot and if folks have a chance. Chair, may I introduce the motion?
yes, please.
I would like to make a motion to rescind our previous vote on amendment 16, clarifying reasonable expenses for reimbursement that Commissioner Muchler brought. I would like to lay the matter back on the table and offer a substitute to the original motion. I think I need to make that motion first and then make the rest, but I'll read this out loud just so you know where we're going here. I would motion to substitute to amendment 16, if that motion were approved, with a small necessary change in title, adding any joint sponsors who wanted to sign on, including me, and basically this would just require a per meeting cost allowance for charter commissioners. And this is with the intention of, we've spent tons of time debating this and talking about how to deal with the fact that our costs aren't really covered. How can we do this? How can we make sure that the county actually does reimburse costs or cover costs in some kind of a way that is enforceable and that is like actually complied with? And so this would do that. It basically changes that sentence in the middle of the paragraph to say, members of the commission shall serve without salary, but shall be paid a flat opt-in per meeting cost allowance of no less than $65 per meeting for no greater than 5 meetings per month. County council may not lower, but may reasonably increase this cost allowance amount by simple ordinance to adjust for inflation. So that's what this proposed amendment would do. And I'm happy to like get into discussion of that if we feel that if we vote to rescind that motion and move this substitute. But I think we might need to take those motions one at a time. So I would motion that we rescind that vote on amendment 16 to quickly discuss and vote on this substitute motion. Do I have a second?
I'll second that. Any discussion? Go ahead, Commissioner Muchler.
Well, first of all, thank you, Commissioner, for reaching out to me. I was camping today. Yesterday or today. I thought about this and, all of us ran and prevailed in our elections. Congratulations, by the way, knowing we wouldn't get a set. And I still think it's one of the finest, smartest, most dedicated group of Whatcom citizens I've ever been and spent time with. So what we're doing now is working, and I'm just too tired to figure out how to pay us in 10 years. It's just not ours to it, so I don't want to support this.
Okay.
Move to adjourn.
Okay. I'm guessing this is not gonna be easy to do by unanimous consent, so I'm gonna ask for a roll call please on this. This is a motion to rescind the vote on amendment 16.
John Muchler,
No.
Hannah Ordos,
No.
Joe Pittsjordan,
Aye.
Andrew Redding,
Yes.
Jessica Ranstra,
Yes.
Rod Stump,
Nope.
Jennifer Wright,
Yes.
Doug Chadwick,
No.
Eamon Collins,
Yes.
Liz Darrow,
Yes.
Joe Ellenboss,
No.
Lindsey Graham Ellenboss,
No.
Colton Coltonfeld,
Yes.
Brad Kelly,
No.
Maya Morales.
Yes.
Forgive me, council, is a motion to rescind a 2/3 or simple majority?
Without prior notification of this
It
2/3.
had prior notification. I didn't know this earlier.
Leave that up to the chair to whether this counts as prior notification.
Same as I did earlier. I think if an email has been sent, I gave that same respect to Commissioner Ordas so many hours ago. So in my mind, that means that that's been rescinded. Does that make sense? Yep. People understand that?
Okay, so now I will motion the substitute. So motioning the substitute, I already read it out loud. Changes the title to requiring a per meeting cost allowance for charter review commissioners. Keep in mind, this is in 2035. And then changes it as I already read before. And I want to just justify this and explain a few of the bits of language that I put in here. I will also mention, I'm very surprised by this statement by Commissioner Muchler. I understood that I had to support moving this forward, and so that is catching me very much by surprise. When I put in here that folks shall be paid a flat opt-in, the goal there was to address any kind of issues that any future commissioners may have with accepting anything that was taxable income. And if they felt that it would be a tax burden for them, they could opt to not receive this. So this is an opt-in cost allowance per meeting. As with the way that our commission's gone, I highly doubt that in most months we would go beyond 2 official meetings. And so while this does cap it at 5, in case there was like a month where there were like 6 meetings or something, it's not anticipated that a future commission would have 5 meetings per month, right? It's anticipated that they would have 1 or 2. And so that is how this is framed. This is something that I decided to propose because we talked about it so much and we almost passed, I think, Commissioner Muchler's proposal. And then ultimately there was some vague language in there that felt like we'd have to struggle with enforcement again in a future commission. So this is just a gift to the future commission to make sure that they have costs covered in some type of way that is flexible. If folks wanted to use it for childcare, if they wanted to use it for snacks and coffee, if they wanted to use it for gas, whatever various commissioners around the county needed, they could just have covered. And so that's what this is about. And I would like to move this amendment for a vote.
I'll second that. discussion? Commissioner Redding.
Commissioner Fitzjordan informed me recently that he did some research on this issue and found that if you pay out more than 200 a month, I believe, it triggers the requirement for healthcare and things of that kind. Would that be true there?
What my understanding was, based on what I had heard, I'm not, I did not verify explicitly within county policy that that is the explicit policy, but would look to any folks who.
I am not aware of any policy like that from the county, but I've not researched it directly.
If I can say that, I can say, I mean, just as someone who's worked in both HR and with labor law, I don't think that that's correct. Yeah. It would be an employment classification that would determine benefits, not a certain number. But thank you for that.
Okay, Scott, could you please call the roll?
Hannah Ordos,
No.
Joel Fitzjordan,
Aye.
Andrew Redding,
Yes.
Jessica Ranstra,
Yes.
Rod Stump,
No.
Jennifer Wright,
Yes.
Doug Chadwick,
No.
Eamon Collins,
Yes.
Liz Darrow,
Yes.
Joe Ellenboss,
No.
Lindsey Graham Ellenboss,
No.
Colton Coltonfeld,
Yes.
Brad County,
No.
Maya Morales,
Yes.
John Muchler.
No.
That motion fails 8-7. I would accept a motion to adjourn.
So moved.
Second.
Any,
Oh, yes, me too.
this meeting's adjourned at 11:07 p.m.
I'm gonna get my reports done tonight.